All right. Order of Appeal in and for the Fifth District of the State of Florida is now in session. The Honorable Brian D. Lambert, Chief Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. And God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Hey, there you go. Yes, we're going. You've been a good audience. Thanks for having us. Good morning. Welcome to another session of oral argument here. A little bit away from our usual venue over in Daytona Beach, but we're pleased to be here at the downtown UCF campus. As our marshal over there, Charlie Crawford, has indicated, I am Brian Lambert. I am the chief judge presently on the court. Another 15 months. And seated with me on the panel to my left is Judge Kerry Evander. Judge Evander used to be a trial judge in Brevard County and been on our court for a long time. And to my right is Judge Jay Cohen from Orange County, also was a trial judge in Orange County. So you got a very, I used to be a trial judge in Marion County. So we're appellate judges and trial judges. So very experienced panel you have with us today. I thank the attorneys for participating in the Law Day oral argument. They indicated that the notice that was sent to you all indicated what we'll have at the end of each oral argument case. We'll have the attorneys kind of introduce themselves and give a little background, and then we'll have a chance after each case is concluded for any students who want to ask questions of the attorneys or the judges, not necessarily how we're going to rule, but just any questions about the process or the case, and we'll be happy to answer as best we can. Before we get started, I would like to thank some people for helping us come here today and putting this all together. Dr. Timothy Ravitch, your department chair, also the various members of the legal study staff, Katie Connolly, Sean Donovan, Amy Maciel, Cameron Worcester, and all the faculties and students of legal studies department here at UCF. We're pleased to be here. That said, we're getting ready to go. Our first case, we have 3 cases this morning. Each case, there will be 20 minutes per side for oral argument. Our first case is case number 21-1980. I think you all have pamphlets here that gets a little bit of an outline about what each case is about. Couple things, please, so as to facilitate the oral argument, if you have any type of electronic device or phones, please either turn them into the off or mute status so they don't go off and interfere with the attorneys during oral argument. That said, first case, 21-1980 is Neil Thomas Barzano and Lisa M. Barzano versus JSK Inc., the Florida Corporation, and various other corporations there. So I will, Mr. Dixon, I'll set aside 5 minutes for rebuttal. If you want something different, let me know and we'll coordinate that. But that said, you ready to proceed, sir?
I am, man. Please the court. My name is Kevin Dixon, 210 West Highland Boulevard, Inverness, Florida, 34452, representing the appellants, the Barzanos, in this matter. Your Honors, this case comes to you on appeal of a final judgment enforcing a settlement agreement. It's a written agreement. The appellant raises 2 issues. The first issue being that there are 16 findings of fact in the final judgment and they are not supported by competent substantial evidence. The second issue is the trial court's interpretation of the party's written agreement, which comes to the court on a de novo review, which simply means you're on the same footing as the trial court. You can read the contract and tell us what it says. Addressing the first issue.
Well, let me ask, Counsel, admittedly, there wasn't any evidence, admit this in the evidence in front of the judge, but when you went to the hearing, I mean, there was really no dispute that a settlement agreement was reached between the parties. And the only issue was about whether it met or exceeded the code, Citrus County code, about this driveway they want to put in.
Correct, Your Honor. There was a settlement agreement that was entered into. Our issue one was, well, okay, it exists, but you really didn't introduce it into evidence. So technically, that would be our evidentiary argument along with the other things.
Did you file the memorandum in response or, pretrial memorandum and you all advised the court that there's one issue, the interpretation of the language. There was a settlement agreement. There was only one issue for the court to resolve. Why can't the trial court, accept the fact that you both told them there's one issue only, and just deal with that issue?
Well, the trial court could do that. And in fact, the court did that. If you look at the transcript, and I think we've cited a footnote.
Well, the reason for that question is why are you raising an appeal when your pretrial memorandum below, it wasn't a contested fact?
As far as the existence of a settlement agreement?
Right. The only question here is the interpretation of the agreement.
I think today that's the key question for the court
Well,
today.
but you briefed it.
Well,
And
we,
we had to read it because you briefed it.
correct.
Look at the record, when really none of those facts are in dispute.
Well, most of the facts are in dispute. The only fact that's not in dispute is the existence of the settlement agreement. And when the court made these
Really?
findings of
Then
facts,
let's take a lot of time out of your oral argument, and we can go through the facts individually and see whether they're disputed. You entered into a settlement agreement. It required the grant of a 20-year agreement for ingress and egress, correct?
that's what the settlement agreement reads, correct?
It required the construction of a driveway, correct?
Meeting and exceeding the county code,
Right.
correct?
Which is going to be the critical legal fact.
Correct.
And then you all opposed the construction of the driveway during that process.
There's no evidence of that in the record.
Do you dispute that fact?
My clients didn't know that they were,
Did you-
there's been no
did you
construction of this.
dispute the fact that you all opposed the construction of the driveway?
No, Your Honor.
Okay, so that means that we have no contested facts here. It's a legal issue as to the interpretation of that agreement.
That's incorrect. All right, there has been no construction of a driveway. All right. The only objection my clients had was the type of driveway that was going to go in. That was the dispute they had because the agreement said meeting and exceeding, and the appellee wanted to get a variance, which is at the antithesis of meeting and exceeding.
But that's the issue, is
That's
there's
the
no dispute that they sought and obtained a variance from Citrus County to put this in. And your position is that because you had to do that, JSKA, because you had to do that, that is indication that it does not meet or exceed the county code requirements because you had to get a variance to the code to do that, and therefore that agreement, you're not in compliance with the agreement.
Well,
Isn't that what that is?
we realistically don't know. We believe they applied for and got the variance, but we weren't made a part of that process. And that was the objection we had, that they went around behind the appellant's back and applied for a variance. Now, they came to the trial court claiming that they got a variance, but there was no evidence of that.
So you don't think they have a variance?
In all likelihood, they probably do, but we haven't seen it, and there has been no evidence before the trial court on that issue.
But in the memo you filed with the court, you said there's one issue, interpretation of the language of the settlement agreement. So that seems to be, what the judge ruled on is that, and then you all made your argument. In fact, during, the transcript reflects, you both said this is the issue here. So not just in the memo, but in the argument, this is the issue, whether language should be interpreted to say that if you have to get a variance, it does or does not meet the code. So
I agree, and the court specifically referenced it and said that's the whole gist of the issue when she was speaking with the appellee. And I believe that's what the court tried to do. But the findings of fact simply aren't supported by anything. So I think the main issue for us, and as Judge Lambert pointed out, there's just no evidence in the record, So the only other issue then would be what would be the correct interpretation of that settlement agreement.
You know, there's probably some findings that are not particularly material, but weren't supported by the evidence, but the material findings, are there any material findings the judge made that you think you did not agree to in your response to the, or your memo, your pretrial memo?
Disagree with as in technically, or because it affects my client, because the court.
I'm asking material facts that the trial court found, material to the resolution of what was before the court. Is there anything in particular that you disagree with that is necessary to the resolution of this case?
As far as interpretation, no.
Okay, so why'd you focus on the second issue?
Because my clients didn't agree with the final judgment, and if we could get it reversed on any basis, all right, that's what we were seeking
So
to do.
just throw whatever up against the wall.
No, we looked at it,
See what sticks.
I'm sorry to interrupt. We looked at it, it was a valid issue because the court made findings on no evidence. That's a reversible.
I think you're getting a sense that the three of us don't necessarily agree with that. And so you've spent now almost 7 minutes of your 20 minutes talking about an issue that really isn't of any import, when you should be talking about the legal interpretation of that agreement.
The issue of the factual and or lack thereof was about 5 minutes of my presentation. I agree that the main
It's been
issue
about
is,
7 minutes of your presentation so far because you've raised that as an issue.
okay,
Want to go ahead and talk about the legal issue here?
Which we think is the critical issue.
right. The issue with the settlement agreement is it's a written contract and the law is clear that this court again gets to review it and make its own interpretation of what that particular language in the contract says. What this particular settlement agreement says is my clients would allow Applee to construct a driveway on their real property as long as it is meeting or exceeding the current county code. That's very plain English, and I provided in our memorandum the Webster's definition of both the meet and exceed. Meet, exactitude, exceed, over and beyond. As pointed out, the Applee couldn't meet it and then went in to get a variance. Well, the variance by its very nature, by its own terminology, does not meet or exceed the current county code. And we cite the Redner case for that aspect.
The trial court found that because the code includes the opportunity to get variances, that it is part of the code. How would you respond to that?
I don't dispute that there are variance provisions in the code, but a variance by definition is allowing somebody to use their property in a method that is otherwise prohibited under the code. So you're not meeting the code, but based on a hardship, we're going to make, I hate to use the word exception, but we're going to allow you to do it. We're going to allow you to do something less than the code based upon this hardship. That doesn't get you to meet or exceed. It's never going to get you there. All right. And so when the trial.
But do we go back and look at the initial sale of the property? So the property gets sold and the property consists of a tavern and a packaged liquor store. And the packaged liquor store, for whatever reason, seems to be a real big part of that business. And then your clients take actions that effectively obstruct ingress and egress to that package store. Doesn't that defeat the whole purpose of the initial sale of the property?
No.
Why not?
A, they're both businessmen. B, my client owned commercial property next door, which obviously could be developed any way he sees fit. It's only the Applee's position that the drive-through package is a material part of the business. It's a tavern. It's not a liquor store. And so,
When
if
your clients owned it, did they have a tavern and a package store?
yes. All right. And it had it.
Oddly enough.
Pardon?
Oddly enough.
I don't know. It's always been a tavern and a liquor store. Had the drive-through access been material or important to Appellee, then they could have negotiated. something different when they purchased the property. They knew they weren't buying the commercial property next door. And so, was that a failing on their part? Probably. But that really has nothing to do with my client's ability to develop commercial property next door. Now, turning back, if I may, to the interpretation of this contract. The law is clear, and it looks like what the trial court tried to rely on was the doctrine of this implied duty of good faith and fair dealing. The problem with the court's reliance on that is it modifies the terms, the clear, unequivocal terms of the settlement agreement, and transforms it from meeting or exceeding into, I believe it was, anything reasonably necessary to support the drive-through. All right. Well, we're arguing over an easement, a driveway. Now the court has ordered my client to do everything reasonable to support a drive-through, which kind of is an absurd interpretation of the contract. And I would give two, taking it to the extremes examples. Well, if my client has to do everything to support the drive-through, if the drive-through needs a new canopy, does my client have to put that on there? The other issue, if you look at just the zoning portion of it, if the county came back and said, all right, you can install this driveway to meet the county code, but you can only do it if the commercial property next to you is vacant. Well, everything necessary to support this driveway is going to require the appellant to rip down his commercial building. These would be, again, I'm taking them to the extreme, but that's an absurd interpretation of meeting and exceeding.
Didn't the agreement that you all entered into grant them a license for ingress and egress for 20 years? That's
exactly what it says.
Okay. And without any type of variance that is frustrated in purpose, is it not?
No, and then the fact that the appellee made a bad bargain, this is my client's personal property or real property.
Well, your client didn't have to enter into an agreement either, did they?
It was a settlement agreement. There were a lot of disputed issues. There were competition violations, all types of things going on. And so everybody compromised when they entered into the settlement agreement. And again, they're favored under the law. Did my client have to give ingress and egress? No. If you actually look at the pleadings, they were trying to allege a prescriptive easement. Well, that's a legal nullity because my client owned both the properties. All right. So did my client have to grant any type of license or easement? No, but that was part of the settlement agreement. And what was important to the Barzanos, which is why it's in there, if you're going to be building something on my real property, you're going to have to meet or exceed the code. Appellee agreed to that. The fact that they come in later and realize they can't do it, well, they made the bad bargain, not my client. And the law is also clear that courts cannot modify, and in particular settlement agreements, to relieve somebody from a bad bargain or reduce the hardship on this negotiated arm's length transaction between the parties.
So what did meet the code or exceed the code refer to? Was it the materials used in the driveway? Was it how far they were from the, as far as the setback? Was it how wide it was? What did meet or exceed the code mean?
Well, that was one of the other problems we attempted to point out was, there was nothing presented to the court what the current code was, et cetera. In reviewing some of the attachments that the appellee supplied the trial court, it would appear to be a setback issue, not necessarily the type of construction that was going on.
Now, if you didn't have a code requirement and you just have a license for ingress and egress, wouldn't there be a reasonable qualifier, to allow reasonable access to and from the property? In other words, if you didn't have that code provision, but your client agreed to provide a 20-year license.
That's what they agreed to.
Right, to allow for ingress and egress.
But
even if you didn't use the word reasonable, with the law, in essence, place that term in there.
Well, I think real property owners are free to alienate the property as they see fit. So if my clients entered into an agreement that, hey, we'll grant you a license, I think that's going to be legally enforceable. All right. But what was important to the Barzanos, because it is their real property, they didn't want, rutted trail, mud tracks, whatever. They said, no, you're going to build it up to the code, meeting and exceeding. I mean, that's important terminology for my clients. And that's what they agreed to. And so when the trial court it went to interpret, it just ignored the plain language. And under the existing case law, it just can't do that.
Okay, Mr. Dixon, you're in your rebuttal time. If you want to keep going, that's fine.
No, I'll reserve that. Thank you, Your Honor.
Very well. Thank you, sir. 412 left on rebuttal. All right, is it Laurent?
LaRoe,
LaRoe.
may it please the court. Luke LaRoe, 2240 Bella Road, Clearwater, Florida. Thank you for the privilege of being here. I represent JSKA Incorporated. John and Shelley Weekman are here with us today. They're the principals of the corporation. And from the comments made.
Would you agree that there was no evidence presented to the trial court, admitted into evidence?
Was there an effort to admit anything into evidence? No, I did not do that. What I relied on was the exhibits that were attached to the motion.
Which are not in evidence.
I believe there's a rule of civil procedure that says that those are, if you attach those to a pleading, which I viewed this motion as a pleading to enforce the settlement agreement. That's why I went out of my way to attach the settlement agreement and then the two letters from Mr. Dixon, first opposing the variance and second opposing the agreement with the permit that was obtained after the variance.
I don't think you'll find any rule that says if you attach exhibits to pleading that they're automatically admissible in evidence. I think what may have saved you is that in their response, opposing counsel agreed to certain facts and agreed to that there's one issue in dispute. But otherwise, if you accept your argument, you could attach all sorts of admissible things to a pleading and say, well, it can come straight in evidence.
I think it's 1.130 that references contracts. And obviously I was relying on that in attaching the contract and not to sound like
Part of the
I'm
pleading, but it doesn't mean it's admissible in evidence.
And I will totally agree with that, but not to equivocate that, this was a Zoom here and we try to send everything in advance. I did submit all of the materials relative to the variance in a request for judicial notice. Mr. Dixon felt that that was not timely and I agreed to that. So I didn't rely on that in making the argument. I simply stuck to both the comments made in the motion. I relied on those exhibits to the motion. I relied on the fact that what was identified as the only issue was whether or not this actual language of meet or exceed the county code was something that my clients had complied with in getting the variance.
Well, you might consider rereading the rule and analyzing it in terms of whether it constitutes admission into evidence documents that you've attached. But let's go ahead then and deal with the legal issue in terms of the agreement.
Well, very good. And I think that if you've reviewed all the materials, which you clearly have, these folks, these neighbors have had disputes from the very moment that this business was purchased years ago. The first thing that we had to take care of was there was another business opened up the street that violated the distance restriction of the non-compete. And then there was a building built in the adjacent lot, which itself, certainly in our complaint, was a violation of the county code because it didn't meet the setback. And that was what actually precluded the use of this easement that we referred to. We submitted affidavits from, I think, more than 20 people that easement was used as the
A lot
facility.
of this is not in the record, so you can't argue. So what does meet or exceed the code mean in this settlement agreement?
From our perspective, it means it's a component of the county code that if you can go through the proper procedural process and get the county to approve whatever it is that you're asking for, then it meets the county code. I don't think that the argument that this needs to be some kind of impenetrable, inflexible, complete denial of any use of the code that would allow the development that my clients were seeking to enjoy the benefits of the bargain that they made in first buying the business, which this drive-through was represented to them as being a massive profit base for the whole operation. And then to lose that and then enter into a settlement agreement that essentially says you have a license for 20 years and you can do this. And it's very specific about who bears what expense for what aspect of the development of this drive-through easement that was part of the license agreement. It's all very clear. And I think that no one anticipated, and this is the beauty of contracts, no one anticipated that meet or exceed the county code would become this very significant point of contention. But when it was finally determined as going through the process that a variance was going to be needed because of some, some issues as far as what was constructed next door to get around that, then we went through the process. We went through great expense to put together the engineering plans, to submit it to the county. They reviewed it. We had a couple of public hearings, and I think they were aware that there was an objection to that, but the county, aware of the settlement agreement, went ahead and approved it. And I think that in applying for the variance and going through the processes, and ultimately, if they hadn't been approved, then I have no problem admitting that we would not meet or exceed the code as far as requesting a variance to establish the driveway. But since that variance was given, and I think it's clear certainly in, what I would suggest might be the self-authenticating letters from Mr. Dixon that acknowledge that, and his responsive papers, that's the only issue. And I think that it really does come down to what was the meeting of the mind? What was the actual agreement that was entered into when my clients purchased this business in the first place? And that was-
Isn't your position just simply that the code permits variances because the code permits variances and you got a variance, therefore you've met the code requirements and therefore you've complied with the settlement agreement?
Absolutely.
That's your.
That's it. I don't know how much more I can elaborate on that in 20 minutes, but that's it. We got what we asked for. It's a component of the code. So from our perspective, and again, the judge ruled that the implied covenant of good faith and fair dealing, that's part of the code. We got it.
I guess if you didn't want to have a variant, if the variance, if you wanted to preclude getting a variant to comply with this, you could have put something in the contract that says meeting and exceeding the codes does not also entail getting a variance to the code. I mean, you didn't do that. I mean, that would, obviously, if that was in there, that says you can't go get a variant.
If that was in there, we
then-
would not be here.
Then you would have lost. You should have lost below and you would lose here if the judge. said-
Admittedly, I would not have been able to make an argument like I'm making now in good faith if that was actually in there. But meeting or exceeding the code from our perspective, we faced the county. They told us what we had to do to get their approvals. We went through that
What
process.
does exceeding the code mean? I mean,
Pardon me?
what does exceeding the code mean?
I don't really know. I guess meeting the code is nice. Exceeding the code means that I guess if you have to have a 5-foot setback, if you have a 6-foot setback, then you meet it and exceed it by some. I mean, it's really, those are terms of art, and I didn't draft it, although I know that there's a provision there that says you can't blame anybody for the way it was drafted. Equally responsible for the way it's drafted. But again, from our perspective, and I've said this before, I'll say it again, the meeting of the minds, the covenant of good faith and fair dealing, there is absolutely no lawful basis for the appellants to obstruct my clients in getting what they actually bargained for in the first place, which was the use of this drive-through, to its greatest and best use.
So how would you get to find out what the meeting of the minds is in the context of your opponent says the contract's unambiguous? Would you even get to any evidentiary issue about who met what when they entered into this agreement regarding this provision?
I would agree it's not ambiguous, but from our perspective, meeting the code means there's a provision in the code that you can avail.
My point being, if it's ambiguous, then you would get parole evidence as to what was the intent. But if it's unambiguous, then I think parole evidence is generally precluded in that scenario because the contract says what it says, and you don't get to say, well, I know it says what it says, but that's not what I really meant.
Well, I don't think we need to go there, but I would totally agree.
Well, you don't, I would, because your opponent has conceded or stridently took the position that's unambiguous.
I think it's
His
unambiguous too.
interpretation is if you have to get a variance, then you've not met or exceeded the code, and therefore you've not complied with the settlement agreement, and therefore it should be reversed because the judge was wrong. In essence, it's a matter of law, is basically what we're coming down to.
If
That's
that's
the
what,
whole point of the discussion about why we were having, whether there was evidentiary findings or not, based upon no real evidence admitted. It really has come down to a legal question as it was presented to the trial judge and as it's presented to us. I mean, that's what
Pure
we're
and
here about,
simple.
right?
pure and simple, absolutely correct.
So it's fair to say you both claim the provision's unambiguous, but you both use different meanings, different interpretations.
Isn't that a wonderful thing? That's exactly correct. I
Well, we
mean,
have a
to
court,
me,
right? That's why
meeting the
you
code, part of the code, there you have it. That's why it's fun to do this. All right, unless you have any additional questions, I really appreciate the privilege. Thank you very much.
Yeah, okay, thank you, Council.
Thank you, Your Honor. Just briefly.
Yes, sir. We got 4 minutes, so it'll be as brief or as lengthy within that time. as you
All
want.
right. Everybody, including trial court, found this language to be unambiguous. And once you get there, like,
It's because y'all argue, it's unambiguous.
all right. And they keep going back to this, modifying the language based on this doctrine of good faith and fair dealing. But when you look at the actual case law on that issue, and in particular, we cited insurance concept design, there are restrictions too, but the first one says that the doctrine should not be invoked to override the express terms of the agreement between the parties. That's what the trial court tried to do here with that doctrine. Meeting and exceeding is unequivocally clear. Those are plain language, plain definitions. And how the trial court goes from meeting and exceeding to completion of all things needed to facilitate the installation of everything necessary to support the drive-through just doesn't, you can't get there.
Meeting and exceeding doesn't set forth the code provisions either, because that's not how you draft documents. But if you would wanted to preclude a variance, that could have been in the agreement as well, correct?
Well, there's a multitude of things that could have been in there, but what it says is plain language, meet the current code or exceed it. That's it. That's as far as we get when we have the plain language. Now you keep hearing, oh, we went through the variance and variance because it's in the code, meets and exceeds, and that's what we, believe that why the trial court's correct. But if you actually look at what the appellee submitted to the court, the meeting minutes of the Planning and Development Committee, you have the director, you have the vice chair, and you have the #1 planner all saying a variance does not meet or exceed the current county code. So had they actually got evidence in, I don't think there would be enough evidence to support the court's
Just
ruling.
like they can't argue what's not in the record, nor can you.
Correct. But I'm saying, they keep pushing that. And what I'm telling you is that the county's own people interpreting it are saying a variance doesn't.
There's no evidence in the record of that.
Correct, Your Honor.
So stop arguing it.
All right. The only other thing I would briefly bring up is the Flamiglio case that both parties decided. And again, that case says you can't get to an observed result with an interpretation, and also stands for the standpoint that you can't, in interpreting a contract, the trial court can't make a better deal for somebody else. And that's what it appears that the trial court tried to do here, and the case law just doesn't support that. Thank you.
All right, thank you, Council. Okay, all right, Council, if you, we'll start with Mr. Dixon first, since you were the appellant's attorney. If you kind of turn and face your audience here and tell everybody who you are and how long you practice and what do you do and things like that, and we'll go to Mr. LaRue.
Thank you. My name is Kevin Dixon. I'm a Florida. I'm from Inverness, Florida. I've been practicing for 26 years. I've come to court multiple times. It seems like every time I do, I show up in the wall. It's hard enough arguing with these guys just when they're by themselves, but having y'all back here is not help. If you have any questions, I'll be happy.
What type of practice do you do, generally?
Oh, I do all civil litigation. It's easy to tell you what I do. Inverness is a small community, Citrus County, so I don't do family law, don't do criminal law, don't do bankruptcy, don't do probate. But anything else that walks in the door, small town, you're taking it and you're going there.
Mr. Dixon, how long did it take you to prepare for the oral argument today?
I spent 7 hours preparing for the oral arguments.
Does that include the writing the brief, or that's beyond?
No, that took considerably longer because of the research that's involved. I think all told, if I had to guesstimate, I probably have about 20 to 25 hours in trying to get the appellate brief and then go over it and put it down and look at it again and go, no, that was done, let's do this. So it does take some time.
And where'd you go to law school?
I went to law school at the Cumberland School of Law. That's in Birmingham, Alabama.
All right.
Any questions? None? All right, thank you.
All right, Ms. Dixon, thank you. Mr. LaRue?
Well, good morning, Luke LaRoe. I've been a member of the bar since 1987, and I went to Florida and Florida State. Didn't have the pleasure of going to UCF, but I went to law school at the University of San Francisco. I went to night school. I worked during the day in a printing and advertising company. And I've been a member of the bar since October 30th, 1987. I do all kinds of different things, but I just want to make one important point. This gentleman is a dear friend of mine, and we've been on the same side of many cases, and we've been against each other on many cases, but it's always been a privilege. And when you're able to litigate with somebody that you have great respect for, it's always a lot more fun. It's always a real pleasure to work with this fine gentleman. He's from Citrus County. I've had the opportunity to drive up to Citrus County to take care of various cases now and then. And then, as he said, when you were a sole practitioner, you really want to be a little bit more broad in your acceptance of people that will come in the door that might have that all-important access to that important witness, Mr. Green. So that's the best part of the whole thing. Now, in most of this work, and I think anticipating some of your questions, I probably worked the same amount on this case. This case goes back many years, and it's obvious that when you have things like a normal contractual issue, you buy a piece of property, something goes wrong, you can end up litigating for years and years and years. And I'm not impugning his clients or saying anything about my clients. That comes with the territory, because it's natural when you have something, no matter how much effort you put into crafting an agreement that you think covers everything. There you go. Here we are. We're fighting over one little term in a much bigger document, but you see how important that gets. So I think what it does is it teaches us all a lesson. You really have to put as much time and effort into that attention to detail that helps you craft agreements and virtually everything you write in the right way. I don't want to belabor the issue. I'm happy to answer any questions you have.
Are you a sole practitioner, sir?
I am,
Okay.
yes.
Did this hearing before the judge below, did this occur during COVID time? I mean, the peak of COVID?
It actually did.
Did that affect how you all appeared in the trial court, or how you prepared or presented your case?
It did, because, as opposed to being able to hand something up to the judge, we had to get it in advance. I know my clients lost their connection, so they weren't there, and it was a real struggle, but obviously we all have to improvise and adapt. It made it different, but as with everyone, and certainly as with this court, you do what it takes to get the job done. And I think that, regardless of the outcome of this case, everybody worked hard to get to this point. And I'm just grateful for the privilege of being here in front of you all this morning. Thank you very, very much.
All right, counsel. All right, thank you.
Thank you very much.
Yes, sir. Any questions from any of the students? Of either the attorneys or the judges? No? No? All right. An older student over there, but all right, go ahead.
I got one question. Welcome students to the department. I have a question, if you can speak in a general way. I think I caught some issue here, difference between evidence and procedure.
Well, I mean, what we were talking about, the actual evidence is, when you're in front of the judge and you want to have a document admitted into evidence, typically you have to have somebody identify the authenticity of it. And then you then ask for the judge to formally admit it into evidence. I'd like to move this contract or this settlement agreement into evidence. Trial judge would look and say, well, is there any objection to it? And if there is, then the judge would rule. Procedure, talking about attaching documents to the complaint, there's a rule of procedure that if you're bringing an action on a document, you have to attach it to a copy of it to the complaint, but that doesn't automatically make it an admissible document. It may very well be in the presentation of, whatever hearing or trial, but in and of itself, just attaching things, as Judge Evander pointed out during the oral argument, especially when we get pro se or, people who are not represented by counsel, they may attach all kinds of intriguing pieces of paper to whatever they file, their complaints or motions that may have nothing to do with whether they should be admitted or not, but to them, it's of significance for whatever reason. That doesn't become evidence that's considered by the trier of fact, either a judge or a jury. So simply the attachment of a document to a filing in the court file is not evidence. It actually has to be admitted into the evidence for the judge.
One of the things that you saw during this oral argument speaks to what the role of the appellate court is. And that is that we're not here for a redo. We are a court of correction of error. And so when the case comes up to us, we get what's called the record on appeal. And that record on appeal can be thousands and thousands of pages. But whatever is in that record of appeal is what we review in our preparation for an analysis of whether the trial court was correct or incorrect in the rulings that were made. And so that's why you're hearing discussions, because if it's not in that record on appeal, for our purposes, it doesn't exist. So we don't let people come into oral argument and raise things that are not within that record on appeal for that reason, because it's not a redo.
And as far as the attorneys talked a little bit about their preparation, our preparation is, as Judge Cohen mentioned, we have the record. Both parties have filed briefs where they have to limit their argument to what's in the record and present whatever legal arguments, if we do a statement of facts, legal arguments. When it comes to our court, we each have 2 law clerks. And well, one of the law clerks on this case, one of the 6, prepared a memo. And so it's kind of the neutral brief, if you would. So they go through the facts, what they think are the relevant facts, set forth their analysis, go through case law. So then when we get it, we look at both sides' briefs as well as our clerk's memo. So we have a lot before us as far as what the facts are and what the law is, analysis. Ultimately, we have to come to our own conclusion. But that's a little bit, and I think generally our goal is to be as familiar with the record and the law and the issue as the attorneys, even if they've had it longer. Usually our memos from our clerks are very good, and we try to be fully prepared for the argument.
Because what happens is, we are randomly assigned to cases as judges. There's 11 judges on the court right now. So the 3 of us have been assigned for the cases this week. And for each case, one of the judges is what's called the primary judge. So the primary judge, his or her staff, when we call clerks, they're actual staff attorneys. They're lawyers, that we have working for us. That staff attorney for the primary judge, he or she will prepare the memo. And then again, we get that, and what we do, because there's a limited time frame, there's 20 minutes for each side. So we read everything, and then we try to, get familiar enough to decide what we think is important. And that's what we want to focus primarily on, because lawyers raise various issues, and some may have more merit in our view than other issues. And so we try to hone in on that so that the lawyer can focus his or her time on that issue to help educate us as to their position, and help us to make a better decision when we go back amongst ourselves in conference and decide how we're going to rule on a case. That's kind of the process that we go through, both leading up to the oral argument and after the oral argument. So.
And my law clerks are actually present today, I hope. Eric Zares, Evelyn Schwab, would you stand?
Great job.
Did you say you did a great job?
She said you did a great job and that you're very good looking.
Well, we get some good evidence here. Yes, sir.
So you guys were talking a lot about the variance. Is it typical to have in these appellates one issue that's just really the pretty much focal point of this? Is that kind of commonplace?
It's not unusual. I mean, sometimes we'll have 2 or 3 really significant issues, sometimes more, but a lot of times the oral argument tends to get focused on 1 or 2 issues. So this is not an always to have just to focus on 1 issue, but it's not unusual either.
When I speak to appellate practitioners, my advice to them typically is if you're arguing for more than 3 issues in your brief, typically that's a mistake. If you can't win on your best 3, you're not going to win on your 10th. And then when you get to oral argument, you can have what happened with Mr. Dixon, which is he raises an issue that, as you could probably tell, wasn't greatly persuasive to the three of us in terms of the factual allegations or lack of evidence in the case, primarily due to, the memorandum. But you can get stuck 7 minutes into 20 with talking about something that isn't necessarily going to win the day for your case. You don't want to do that. You want to, at oral argument, talk about the issue that you might prevail on. And so that's the risk of briefing 10 issues in a case.
And the beauty or the experience, the appellate practitioners, it's kind of the theory of, read the room. When you start listening to the judges, what they're focusing on, then even if you have a kind of a plan of how you want to present your oral argument, if the judges are turning in a different direction, like Mr. Dixon did today, you have to kind of shift as he did to, okay, let's talk about what they're concerned about. Let's get on that. Because that was, frankly, it was chronologically his second issue in his case. It's probably his better issue, obviously, because the concern in our case, because, we were all actually former trial judges. So, we see it was presented to the trial judge below that there actually is an agreement, and the issue is what is the variant, does that comport with the plain unambiguous language? And that's what the trial judge below was facing. And so that was what we wanted to understand, how that should be interpreted today, and whether she committed reversible error as a matter of law by, enforcing the agreement with the variance to, so, but that is kind of if you proceed forward in trial courts or, when you're dealing with trial judges or appellate judges, you kind of, whether you think they're going the right direction or not, they're giving you the direction that they want to go, and you need to understand and adapt yourselves to the direction that the court's going during your presentation of a case at the trial court level or in the very finite time that you have in oral arguments in front of an appellate court. So,
As a general rule, when you argue to an appellate court, there's stronger points in your argument and weaker points. And there's an inherent tension because the attorney arguing the case wants to spend all their time on the strongest points. Our questions may well go to their weakest points because they can justify the weakest points, why they should still win, notwithstanding the weaker point. That goes further. So attorneys want to get up and talk about their good points, and our questions are more likely to be directed to their weaker points on both sides. So there's that inherent tension. So as a person arguing, you want to prepare for your best points, but you need to really be prepared for getting questions on your points that may be harder, questions harder to answer.
yes.
Because the documents were attachments that weren't really entered into evidence, does that make it like invalid, so it can't be used in any question?
It's not part of the record on appeal. If it's not in evidence, we don't consider the exhibits because it's not, again, part of the record.
So if it was, if it was entered into trial court, it would be part of the record.
If it was entered into evidence,
It would be part of the evidence.
it would be part of the evidence that would be part of the record on appeal.
I mean, it does physically exist in our record because it was attached, and the context of what happened here was, as we interpret it as a trial judge, there wasn't a dispute that there was a document that exists. It was how do you interpret it? So, the issue was, should it have been admitted into evidence? That would have been the better course, but as it was presented to the trial judge below, how she interpreted it is, well, nobody disputes that this exists and that this is what the fight that was below with her was, should it be enforced based upon whether this getting a variance complies with the plain language of that agreement.
Now, if the issue had been whether that agreement was actually signed by both parties, then you have a different ballgame. Just depends on the nature of the issue, whether the issue was a factual resolution, which has a different standard for review versus a legal issue, interpretation of a contract. The factual issue we would review under an abuse of discretion standard. The legal issue we review de novo, because as Mr. Dixon properly pointed out, we're in as good a position as the trial court was to look at the legal interpretation of the contract. But when it comes to factual issues, we didn't see the witness testify. We weren't there. And so we give discretion to the trial court judge's determination of the credibility of witnesses.
For example, if the judge in his or her judgment says, well, I listened to Mr. Smith and I found his evidence or testimony to be credible. We wouldn't sit as an appellate court if that was an issue. We'd say, well, you know, I don't know what that trial judge is thinking about. We don't think it's credible at all, because the judge is listening and assessing credibility. We're just reading pieces of paper. So we can't determine credibility. We defer to a trial judge's determination of credibility. But when it, you know, there wasn't a dispute that the contract was entered. So it's how do you, what's the legal interpretation of that phrase of the contract? And so that we look at it in the same way, you know, as the judge. We address her ruling by looking at it as the same thing that she was looking at. This is the language. How do I interpret it? We decide whether she erred in her interpretation of that language. And that's what our issue is primarily today in this case.
Just a quick question. What makes you guys like the appellate court versus the trial court?
Why don't we hold those off until we're done at the conclusion of all three arguments? And then we can talk about some, general issues like that.
Sir, you have a question?
Based on what the other justice said, I'll hold out till we ask my question. That's okay.
All right, yeah. And he's a judge. I mean, sometimes you all refer to us either nervously or whatever as justices. Those are actually the men and women on the Supreme Courts, the Florida, we're just regular old judges. And I don't think any of us want to be a justice, actually, frankly, but although a couple people on our court were former colleagues of ours are now justices on the Supreme Court, so good for them. Yes. We're good. All right, counsel, thank you very much for participating with us. Have a good day. Have a safe trip back.
Thank you.
Mhm. Okay, we will proceed to case number 2 of 3 this morning. BMW of North America LLC versus Marie Louise Henry. The case is number 21-885.
People are leaving in droves.
They read
They're leaving the room.
They read the preview here. Oh, my goodness.
Yeah. We're gonna have 3 people left.
That's right.
Okay.
Please the court.
Right. There, somewhere. Okay, all right, counsel, whenever you're ready.
May it please the court, James Wyman of Hinshaw and Culbertson on behalf of the appellant BMW of North America LLC. I'd like to reserve 5 minutes of my time for that.
Very well.
If I may. Since there was a dispute, the appellee raised a question about an extended discussion about the standard review. I'd like to briefly address that. I think it's fairly clear that the standard review here is de novo. We are not talking about the application of a contingency risk multiplier where it's authorized. We're talking about the larger question of whether a contingency risk multiplier is authorized to begin with under federal law.
Let me just, on a preliminary or kind of a secondary issue, what case law do you have that would suggest that allowing a plaintiff below to have a second lawyer would constitute an abuse of discretion?
There is, I cited, I believe it was a case from this district, Your Honor. I cited it in the initial brief. This is we're talking about the second question here on the business judgment, whether the amount of the award itself should be reduced for.
Right.
And I forgive me, Your Honor, I don't have the case.
Isn't that an abuse of discretion standard?
Yes, that would be reviewed. Yeah, the amount is clearly reviewed. There's no question about that under abuse of discretion standard. So that's within the trial court's discretion to say, you know what, I think, I should reduce the time for a second or eliminate the time for a second attorney or allow it. That's a discretionary call by the trial judge.
And then let's get to the crux of this. How would you look at the tension between the Purdue case and the Dodd case?
Well, I don't see that there being any tension at all. I've been calling it DAG because it rounds with vague, so that's the, I almost, it's like, or Daubert, Dober, same thing. You'll forgive me if I always call it DAG because that's what I call it in my head. There is no real tension. The appellee said that Purdue receded from, DAG has a flat out prohibition on enhancements.
I wouldn't necessarily, it's a general prohibition. I don't know.
Enhancements for contingency risks are not permitted. That's the language that Justice Scalia used. So that's to be discuss how one can characterize that, is whether it's a flat out prohibition or not.
And the
But not permitted
Magnuson
is
Moss is a federal act. So,
absolutely, Your Honor. And that's
and so we're bound by determinations by the U.S. Supreme Court about interpretations of federal act.
Your honors have taken an oath that you were bound by, and there's a decision of this court, the Walker v. State from, I've cited it.
But the appellee disputes that.
Beg pardon?
The appellee disputes that, correct?
It's unclear from, I mean, at one point, it seems to be that, well, it's procedural.
That's how I read it.
Okay. Yes, well, certainly the trial judge, the trial judge actually went so far as to say that while, that the Florida Supreme Court could determine questions, was not bound by determinations of the U.S. Supreme Court on questions of federal law in state court. That
They rely on Joyce for that primarily, the Joyce case of the Supreme Court?
no, that was pretty much an unsupported proposition set forth by the trial court. But yes, the trial judge did rely on Joyce to, the order was
A little
confusing.
history, Joyce came from the 50s.
Your Honor, I know both you and
two of us were on
Judge
that.
Cohen were on the,
Yeah.
I did my homework on that.
Two of us were primary on that case that got reversed by the Florida Supreme
Yeah.
Court. One of us was primary.
I was wondering which one of you, and as soon as Judge Cohen spoke up there, I said, oh, yeah, he was the primary. We hid that under a per curiam, but now we know that the truth will out.
That's why we have a Supreme Court.
Yes, indeed. Joyce is, Joyce is, I'm not going to argue whether Joyce is incorrect or not. It's the law in Florida here.
You can't reverse that.
No, you can't. So the contingency risk multipliers are allowed for under 67.428 for in an action involving insurers and their insured. No question about it. That's a matter of Florida law. That is not a matter of federal law. What we're talking about here is a federal statute which provides for the award of attorney's fees. So of course, the pronouncements of the U.S. Supreme Court bind every judge in the state as to proceedings under that statute, including the award of attorney's fees. So
How would you distinguish the Skelton case?
well, the Skelton was pre-DAG. So Skelton and Skelton also involved a common fund. There is in the Seventh Circuit, it's certainly currently permitted there to this day. You can, a trial judge can award a contingency risk multiplier where it's a class action. In other words, and a settlement of the class action, because a common fund is established when a class action is settled, and the attorneys are paid out of that common fund, and that award from the common fund can be enhanced by a multiplier. That's precisely because that's not an award under the statute. That's an award as part of whatever the agreement is with.
Did a fee agreement come in this case?
I do not believe so. No, that was one of the arguments that was made, is that there is a case law that says that if you were looking for a contingency risk enhancement, you have to produce your agreement here. But was a side issue, and that's not really germane. So I did not raise that in the brief, so I'm
Right, but the
hesitant
trial
to pursue
judge
that.
said you can't, the US Supreme Court decision, Dag, doesn't really apply to, it's an hourly, but it does apply if it's a contingency and view this as an hourly. So I'm just wondering what the evidence was on that point. To
Well-
support that initial step by the trial judge.
Right, and that was one of the confusions the trial judge seemed to be confused in making this false distinction here between, or meaningless distinction, actually, I'm sorry, between an attorney who only gets paid if he or she recovers a judgment, a money judgment, and gets a percentage of that. That's a contingency fee arrangement. And a situation as we have here, where the attorney is still working on a contingency basis, but gets paid based on attorney's fees awarded under the statute. I think the confusion is evident in the trial court's order. Personally, I think that and I corrected myself. I kept referring it to alternatively as a contingency fee multiplier, and before settling in the reply brief on contingency risk multiplier, because I see what people were saying. Because if you look at the term contingency fee multiplier, is it a fee multiplier or is it a multiplier for a contingency fee? So that's why I realized that's confusing. Let's call it what it is, contingency risk multiplier. It's an enhancement for contingency risk. That's what it is, regardless of whether the contingency is, it's a contingency fee arrangement where the plaintiff has agreed to pay 35% of the recovery to his or her attorney, or whether it's an arrangement as there is here. We pay Morgan & Morgan, we'll pay you nothing. You don't have to pay anything upfront. We recover our fees based on, if you prevail under the statute. So the judge, it was that going back to that, what I'm calling a meaningless distinction between, an hourly rate. I mean, in Dag, in all these cases, I mean, where there is a proceeding under a fee shifting statute, you have to establish the lowest, it's always the hourly rate. You always have to show how many hours you've expended on the case and what your hourly rate is, and multiply the hourly rate times the number of hours to come up with a lodestar. So it's always, every fee determination under a fee shifting statute concerns the hourly rate. So why did we have this discussion of a contingency fee and a distinction, but made by the trial judge, between a contingency fee arrangement and the arrangement that we had here? We take your case, you don't have to pay anything, we'll get paid, because if you prevail, we prevail on your behalf, we will recover attorney's fees based on a fee shifting provision.
What was the amount of attorney's fees before the multiplier?
Oh, yeah,
It was over $100,000.
Yeah, it was well over $100,000.
And what was the amount that the plaintiff recovered for the loss of value of the vehicle?
It was 11. Well, all told, the judgment was about $11,000.
So the plaintiff was unhappy with her vehicle and
Yes.
BMW, and so she sued under the magnus loss, and she gets $11,000 damage judgment.
She wanted to repurchase as well, and she did not get that.
But the attorney fee, what we're talking about in this appeal is the attorney fees, which is in excess of $100,000 awarded to her client, to her lawyer, excuse me.
Correct, Your Honor.
And then that amount was increased by the trial court judge, correct?
Correct.
And so the total amount awarded after the multiplier was applied was what?
50% more, so it was 165. You'll forgive Your Honor for an eye.
Right.
Generally, that was one fact I just didn't.
As a factual basis for the audience, really.
Yeah, I could look it up if you like, but I'll proceed further. Yeah, so
We actually know what it is.
you probably do. I feel somewhat embarrassed. It's such a basic fact. I'm so focusing on analyzing these Supreme Court cases here that, well, how much was it? Well, I don't know. Your Honor. I knew it was in excess of $100,000. Getting back to Dag versus and what happened with the subsequent Purdue case authored by, Dag was authored by Justice Scalia. Purdue, some 18 years later, was authored by Justice Alito. Purdue didn't concern itself with enhancements for contingency risk. It strictly involved enhancements for superior attorney performance in quote, rare and exceptional unquote circumstances. And the majority opinion
Well, do you think that Purdue is subject to interpretation and beyond just class action cases? Could it be applied to any consumer case?
If there's specific evidence of a superior of those three factors that were set forth in the majority opinion regarding, and it's limited to those factors where, or at least superior attorney performance, where the hourly rate determination does not adequately measure the attorney's true market value. The attorney's performance includes an extraordinary outlay of expenses, and the litigation is exceptionally protracted, and where there exists extraordinary circumstances in which an attorney's performance involves exceptional delay in the payment of fees.
Was Purdue argued below?
Beg pardon?
Was,
Yes, Purdue was, well, it was certainly raised by the trial judge, so yeah.
I'm trying, did the brief requesting a multiplier request?
No, it was based upon those factors. No, it was straight plain vanilla. It was just, we would like a contingency risk multiplier.
And did the trial court make any findings under Purdue?
No, made no findings at all. It mentioned Purdue, but in a way, I don't want to disparage the trial court, but in a way it was not an in-depth analysis of Purdue, let's put it that way. And none of the factors, these rare and exceptional circumstances, were present in this case, nor were they found by the trial judge in this case. So Purdue and in Joyce, our Supreme Court Florida Supreme Court was very clear that Purdue had left the door open a little bit for enhancements under federal fee shifting statutes, but quote, Daig had closed the door on any lodestar enhancements under federal law based on contingency risk. So if you have an enhancement, I go back, Judge Cohen, you don't want to call it a flat out prohibition. There is no flat out prohibition on enhancements per se, but on enhancements for contingency risks under federal fee shifting statutes, it pretty much is, and most courts have agreed that, saying it's forbidden, it's prohibited. The 11th Circuit said as much just a few years ago, saying, well, if we were traveling, if this case arose under federal law, I believe it was a 627-428, insurance dispute fee case. If this were under federal law, a contingency risk multiplier would be forbidden. So it's pretty clear. Most of the courts have, our Supreme Court, the 11th Circuit, has recognized that there is an enhancement for contingency risk is not permitted in cases brought solely under, as in this case, under the Magnuson-Moss Warranty Act.
Right.
Had they brought
if it were state law, the result could very well be different.
Yeah, I think so. If there were a lemon law cause of action here, indeed, counsel brought up, opposing counsel brought up a case in California in which there was an award. It was a Magnuson-Moss case, and there was a contingency risk multiplier applied there and allowed. But in California, and I believe the same is true in Florida, there was also a state law claim, lemon law claim. So where you have that hybrid of both, it's permissible to award it because your proceedings are in part or under the state lemon law. I see I've reached 5 minutes.
During your rebuttal, you continue on if you want, or you want me to stop and save your time.
I'll come back.
Very well.
Unless you don't want to see me for another 5 minutes.
I'm not taking that route.
Okay.
You use your time wisely.
That is my 5 minutes, I reserve that.
Yeah, all right. Very well. Thank you, Counsel.
May it please the court, my name is Ted Green and I represent the consumer plaintiff appellee in this case, Marie Henry. To address a couple of points that
Marie Henry has really no dog in this fight at this point, does she?
at this point, she's been satisfied. Now it's the attorneys who want to get paid. That is
So
true.
really, we're talking Morgan and Morgan.
That is true.
Okay.
That is true. So Judge Lambert asked, so we're bound by decisions of the US Supreme Court. And opposing counsel said it wasn't clear in my brief.
Radical position I took there, right?
Well, it is not a radical position when framed in the general, but there's like so many other things in the law, there is nuance to that argument.
Let's talk about the nuance. Is this a substantive or procedural?
It's a procedural issue.
Okay, then why don't you distinguish for me some cases that were decided by the Florida Supreme Court, specifically Bionetics versus Kennedy and Mendoza versus Progressive Express, where in both cases, they said that the statutory right to an attorney's fee is a substantive right.
That is true, and that is the position I took in my brief. The right to attorney fees is substantive. The method, manner, nature, and scope of the award is a procedural issue. And I know that's true for a couple of reasons. First of all, the right, the entitlement to an attorney fee comes from the statutes. But nowhere, we use, let's set aside the multiplier
So
for only a
it
moment.
comes from the statute. We're not going to set aside the multiplier because that's what we're talking about in this appeal. So the statute in this case, which is the Magnuson-Moss Warranty Act, that is the substantive law that is applied, correct?
With respect to entitlement, yes.
And do you have any case that wasn't a class action case under the Magnuson-Moss Warranty Act where a multiplier was permitted?
The Magnuson-Moss warrant, the short answer is no, and the reason for that is this issue hasn't been litigated widely across the country. However, every fee issue that has been litigated starts with a statute that grants only reasonable attorney fees. There are no statutes, federal or state, that I am aware of that award anything other than reasonable attorney fees. I said set aside the multiplier for a minute. I wasn't going to go too far afield from it, but let's deal with the lodestar. The lodestar is a creature of judicial creation. It is a procedural.
That has been cited with approval by the United States Supreme Court.
Absolutely. But you know, the United States Supreme Court has its own version of lodestar, and so does Florida. They concede that Florida law applies to the lodestar. So my question is, why doesn't it also apply to the multiplier? The other issue is the multiplier is a creature of judicial creation as well. This is why I distinguish between the entitlement to fees being substantive and everything else is procedural. For example, in this case, the statute at issue.
So what do we do with DAG under that analysis? DAG's language that effectively says, unless there are really exceptional circumstances, that there is no multiplier, effectively, we can ignore that under your analysis, right?
There are two aspects of my analysis. The first is whether federal law controls,
You're
and
not going to answer the question.
I am. If federal law controls, we are still entitled to a multiplier. And by the way, the court asked the other side about a contingency risk. We never limited our request to contingency at the trial level, never. We asked for a multiplier. And in fact, if you look at the hearing, the 3-hour evidentiary hearing that occurred, the fee expert that testified, which is me, testified about a variety of different aspects that justify a multiplier. Those aspects that I testified to are expressly authorized to enhance attorney fee awards under Purdue, which came after DAG and modified DAG. It didn't cancel out DAG.
Was Purdue, wasn't that a class action case?
I believe it was, but the fee sought was under a statutory fee provision, 42 USC. It was the 42 USC
And
1988.
did the trial judge in this case make any written findings under Purdue?
He didn't make specific findings under Purdue, but he did make findings. And here's the thing, Purdue allows, and I'm reading from the case, this is why in my brief, I didn't just say, I think this is what the court said. Purdue begins this analysis by saying, we reject any contention that a fee determined by the lodestar method may not be enhanced in any situation. And then they listed a variety of situations where it could be enhanced. They said, first, an enhancement may be appropriate where the method used in determining the hourly rate employed in lodestar calculation does not adequately measure the attorney's true market value. They went on to say an enhancement may be appropriate so that an attorney is compensated, and this is important. An enhancement may be appropriate so that an attorney is compensated at the rate that attorney would receive in cases not governed by federal fee shifting statutes. It went on to say an enhancement may be appropriate if the attorney's performance includes extraordinary outlay of expenses and the litigation is exceptionally protracted. One of the things we testified to at below and gave the trial court evidence of, they call this a run-of-the-mill case. Now, I disagree with that characterization. However, they dragged this case out for 4 years, and this wasn't COVID, by the way. COVID began March of 2019. This case was tried in January 2019. As I point out in my brief, they dragged one discovery issue out for an entire year. We alleged that their dealer was their agent for repair purposes. Their warranty says their dealer is the agent for repair
But
purposes.
you were compensated for the time involved.
An enhancement may be appropriate if the attorney's performance includes extraordinary outlay of expenses and the litigation is protracted. And it also says an enhancement may be appropriate where the payment of the attorneys, that's the very next one. There may be extraordinary circumstances in which an attorney's performance involves exceptional delay in the payment of fees. And we testified about that below as well. We talked about not only them dragging a case out for 4 years, repeatedly causing trial to be continued. But we talked about, even as we stand here today, you asked Ms. Henry, she doesn't have a dog in the fight. We are here in her name, admittedly, because she was the plaintiff. She's been compensated, but we still haven't. So the attorneys who are still waiting to be paid all this time, now we're 2 years beyond the trial period. So we fit that category as well as some of the others. So my point.
Mr. Mayor, let me ask you this. Your first issue seems to be a suggestion that state law controls?
Yes.
Okay. Is there any decision from either the Florida Supreme Court or an appellate court in the state that supports that position?
Not,
There's 2 appellate courts that specifically held to the contrary, right?
not, no, there is one appellate court.
One was Magnuson Moss and one was Truth in Lending.
I thought you were asking about Magnuson Moss. The only state appellate court that's heard this issue is Pennsylvania. The only federal appellate court that's heard this is the 7th Circuit. The 7th Circuit held that a multiplier could be awarded. It didn't say it had to be, and that's not my position either.
You took the position of state law applies.
Yes.
The Joyce case you rely on refers to state statutes. The Florida law controls on state statutes. It does not say it controls on federal statutes. And then the 4th and 1st have both addressed federal fee shifting statutes and have said that the U.S. Supreme Court controls not Florida if it's federal law.
It has appeared to me as I read those
So I'm
decisions.
asking you if you have a single authority from appellate or Florida Supreme Court decision that says that state law would control in this situation.
I have 3, not in the Magnuson Moss context, but I have 3, and I cite them, U.S. Supreme Court decisions that expressly say when the matter is a procedural one, state courts do not have to follow U.S. Supreme Court
The
precedent.
issue you raised here on multiplier. Do you have a single Florida case that supports your position that state law controls in the determination of whether multiplier can be awarded by the trial court?
I have state court decisions, including Supreme Court state decisions, that say that the award of attorney fees are procedural. I have U.S. Supreme Court decisions that say if the matter is procedural, state courts are not bound by U.S. Supreme Court precedent. This is a novel issue, which is one of the reasons I asked for oral argument. This has not been heavily litigated across the country. It's been heard by, this specific issue has been heard by 2 appellate courts. One of them, actually 3, but the 4th said it's within the discretion of a trial judge not to award a multiplier in a Magnuson Moss case. So we have kind of the converse of this decision, and that was Hamilton. They wanted a multiplier and they didn't get it. The appellate court said it's within the discretion of a trial court to decide a multiplier is not applicable. And that was a Magnuson Moss Warranty Act case. So we have the converse of this. And
Let me ask, so let's rephrase, let's rewrite the Magnuson Moss Act just for my hypothetical. So if it actually said, the federal law says, no multipliers are to be awarded, period,
under this federal law.
If that were the case, I would agree it would be substantive law that this court and frankly, the federal courts would be bound by because the
So you
legislature.
would lose, if that's how, if that's, that sentence that I just said, if that was actually verbatim in the Magnuson-Moss Act, you would be losing today.
Yes, sir. However, that statement is not only not in the Magnuson-Moss Warranty Act, it is not in any fee shifting statute that I'm aware of.
Right, but if the US Supreme Court interprets the Magnuson-Moss Act to, in essence, have that sentence, why wouldn't that govern?
Well, I'm trying to think of the permutations because I don't know. You've given me a hypothetical that this hasn't gone to the US Supreme Court. I don't
Well,
believe the US Supreme Court.
has said that if it's a contingency fee risk factor, it's not to be awarded under these federal statutes.
And that's why I pointed out, we didn't ask strictly for a contingency fee risk multiplier. That is not the evidence we presented to the trial judge.
Argument then is if federal law does govern, you're going under Purdue.
My argument is that if federal law controls, if this court were to decide that federal law controls, Purdue allows the award of multipliers in a variety of circumstances that the court expressly says they can be awarded in, and we fit at least 3 of those 5 circumstances.
But you acknowledge Purdue is a class action lawsuit, far different factually than an individual who's representing a consumer for leaks in because their vehicle leaks.
I acknowledge the former, but not the latter. I don't think it's philosophically or legally distinct, but yes, it was a class action. However, the fees they sought were under a federal fee shifting statute that reads very similarly to the Magnuson-Moss Warranty Act. I concede that
if it's a federal law controls and if you're going under Purdue, was the trial judge required to make findings of fact on those factors set forth in Purdue?
First of all, I think the trial judge did make findings that fit the Purdue factors. Secondly, we've talked about what gets waived and what doesn't. They never raise these issues below. If they want to make these arguments, the time to begin them was with the trial judge, and they didn't do that. So they didn't challenge that below, and I respectfully submit, you're the decision makers, I get that, not me. But they waived this issue because they didn't raise that below. They can't raise new arguments. Now, they can add to them at the appellate level, but they can't raise whole new arguments that they never presented to the trial judge, because the trial judge has to have at least the opportunity to address the issue before it gets here. Because as Judge Cohen said, this is a court that looks for error. And the trial court cannot have committed error if they didn't present this issue, and they did not. However, as I said.
So your argument is we can look at the entire record, and if we find those factors, we can affirm.
That is going to be part of my position, yes. I'm trying to give you soundbite answers because I know you wanted something direct. It's not the limit of it, but yes, I agree. I think that if you find that federal law controls, and I try to put myself in the decision maker's role, what would I want to do so I don't stick my neck out? Because candidly, this court, as it mentioned before, has stuck its neck out a couple of times and said, you can't get multipliers. And the Supreme Court of this state has said, oh, yes, you can.
As a state statute.
That is, I'm talking now the philosophical approach to writing opinions. I've often thought that if I were sitting on the panel, I would probably conclude that even if federal law were the controlling law, Purdue allows multipliers in circumstances which this case fits. So we need not decide whether this is a matter of state law.
Do you think
However,
there's a difference in Purdue, they use the term enhancer. Do you think there's a difference between a multiplier and an enhancer?
no, there is no difference in that regard. The words are used interchangeably. And as I pointed out in my brief, one of the things the other side said was, well, they don't even mention a multiplier in Purdue. Well, that's true, but they talk about a 75% enhancement, which is a 1.75 multiplier. I mean, I often tell people if I was smarter, I'd be an engineer, not a lawyer, but even I can do that math. 1.75 gets you to the 75% enhancement. So I think in that case, I think when someone on the panel said potato, potato, it's the same thing that we're talking about essentially, even if it's worded somewhat differently.
I think it's a tomato, tomato.
Then I'm going to correct myself and say tomato, tomato, because that's a much better analogy. Or is it a simile? I think it's a simile if it's like, but I agree wholeheartedly with you in that regard, Judge Cohen.
At least we got that straight.
Yes, sir. So I think for all of those reasons, as I said, even if federal law controlled, we presented evidence to fit the enhancement categories of Purdue. They didn't challenge that evidence. As I point out in the brief, our trial attorney had 28 pages of testimony, none of it objected to, none of it.
It seemed though that the trial court, viewed this as the difference between, an hourly rate versus a contingency where you get 30% of the recovery. And you would acknowledge that it makes no difference that it's not a 30% recovery that you're seeking an hourly rate.
I don't think the trial judge saw it that way. Let me put my other glasses on, please, because you're blurry, so I was trying to see there. I don't think the trial judge saw it that way because frankly, a lot of the testimony we presented and a lot of what they contested was that there were good attorneys in Lake County that could have handled this case. So I don't think the trial judge focused on that, and having been at the hearing, and we've got the hearing transcript in the record, a lot of the challenges that we were going back and forth on were, did an attorney from out of the jurisdiction have to come in to handle it? And there was testimony that there were no attorneys locally who could have.
You would agree as a matter of, just philosophically, that it doesn't make a difference whether they're seeking an hourly basis or whether there was a 30%, we recover 30% of the recovery. That doesn't make a difference, correct?
I'm not sure because this case, if what you're asking, and I'm not trying to be obtuse, I just don't get it. If what you're asking is what would happen with if you're thinking a contingency case is we get a percentage like in personal injury, that doesn't happen here. This is based on an hourly level.
Never happen in a consumer case.
Not in this
Unless it's a
case.
class action. If you've got a single consumer under the Magnuson-Moss Warranty Act, a lawyer's not going to take a percentage of, a recovery on it.
Even so, in our situation, there's never going to be that scenario. Even in a class action lawsuit, that's not quite how it works with Magnuson-Moss, because in a class action, you still have to justify, you still have to get to the lodestar, and the trial judge has to figure out the lodestar amount to award. So it's not like you hear some of these class actions where they have $1 billion.
And maybe, I'll take a second look at it, but it seemed to me that the trial court was confused between awarding an hourly rate versus a true contingency of 30% or whatever the percentage.
I can tell you, I never had that impression having been there. And I never got that impression. I never thought that until here. The last thing I'd like to say, if I may, because I have 1 minute and 3 seconds left, standard of review. Here's the issue. If this were purely a legal issue, it'd be de novo. But once a trial court has authority to act, it becomes abuse of discretion. And my position is whether you view this under the federal standard or the state standard, that is whether federal law or state law applies, the trial judge has discretion to award a multiplier. The analysis in how he gets there is a little bit different depending on the law you look at, but a trial judge is legally permitted under either federal or state law to award a multiplier. And once the trial court has the discretion to act, any action they take is abuse of discretion. And that's why my position is, because these are issues where he could act and did, this court must defer to him under the abuse of discretion standard. And I see that my time is up. So any other questions? Thank you.
Counsel, thank you very much.
Very briefly, Your Honor, Purdue, putting this case, this is like trying to put an elephant's foot in Cinderella's glass slipper. Purdue doesn't apply here. I mean, I see that opposing counsel is trying to get this affirmed on the tipsy coachman doctrine right for the wrong reason. The trial court expressed it, said it twice in its order, that it was applying a contingency multiplier of 1.5. Contingency, not superior attorney performance, something like that. There is The rare and exceptional circumstances that the court in Purdue pointed out do not exist here. In fact, the very first of those three circumstances, which is where the hourly rate determination does not adequately measure the attorney's true market value, as demonstrated in part during the litigation, absolutely doesn't apply because opposing counsel, who was the fee expert here for the plaintiff, actually reduced the requested hourly rate. Mr. Kespel, the attorney before, was asked for $550 per hour. The fee expert, Mr. Green here, actually had that reduced to $475 an hour. That's not an exceptional case.
Let me ask you this. Can Purdue apply?
No. Oh, I beg your pardon. I mean, theoretically, is a hypothetical question. I mean, yeah, if there were, yes. That is the only means of enhancing a fee award under the Mag-Moss Act.
Well, if the trial judge failed to address Purdue as far as express factual findings, and we agree with you on federal law and find that Purdue applied, what's the remedy on remand? Is it say plaintiff you lose, or is it trial judge re-examine this in light of Purdue?
I'm not sure I understand, because
If Purdue could theoretically apply and the trial judge simply didn't make findings of fact on it and you didn't object on it, is the remedy to reverse outright, or is the remedy to say trial judge, tell us whether Purdue would apply or not?
No, I believe it couldn't be, because that would be giving them a second bite of the apple. Purdue was not argued below. Purdue, what the plaintiff argued below were the Florida law factors for awarding a contingency multiplier. It quants from all those things like that.
So they
didn't specifically
argue delay in payment?
No, that was part of that was a fact in the case, but it wasn't argued as, hey, this is why you should award a multiplier. The multiplier was just asked for as on a contingency basis.
Was the Purdue case ever cited to the trial court?
No, I could speak for the defendant. We just argued, Dave.
I'm not talking,
No.
they get their turn too.
It was no. I mean, it was part of it. I believe Joyce was referenced, that line from Joyce that said that, Purdue may have left the door ajar on slightly on enhancements for awards under the Mag-Moss Act. They had completely closed the door on enhancements for contingency risk.
So they didn't then say, and this is the ajar door here in this case.
Yeah. It just didn't come up. It was a much more of a basic proposition that Dade flatly, there's this Volkswagen, and that's one of the appellate court cases in Florida that said no awards, no contingency enhancement for a Mag-Moss case. That was the Volkswagen of America v. Smith case from '97 from the first district. So there is one appellate court case that has flatly said no enhancements are permissible here.
Do you think that the court conflated a contingency in the terms of a percentage of the recovery from an hourly rate?
Yes, I do. That's the only way I can explain that little passage in the order there, because why would we be talking about hourly? If it's always, when you're talking about award of attorney's fees under federal or Florida law, it's always an hourly rate. That's the load. That's half of the loads are there, hourly rate time. So what's the difference? If you're getting recovery on a contingency fee basis of 30%, and you are somehow entitled to, that should be the end of it there. You get 30% of the judgment. I don't know how that would work, because presumably you have an agreement you have $1 million judgment. You have an agreement with the plaintiff that you get 35%. You're going to get $350,000. I don't know why you would seek an enhancement on top of that. That's an arrangement between plaintiff and plaintiff's counsel there. So I see my time is over, unless the court has any further questions.
I think we're good. Thank you, counsel.
Thank you, Your Honors.
All right. Like you were both here for the first one. So, Mr. Wyman, why don't you go first and introduce yourself to your audience here and tell them about your practice and your career, et cetera, what you do.
Again, my name is James Wyman. I work out of the Miami office of Hinshaw and Culbertson, which is a large, approximately 500 attorney firm. Main office is in Chicago. I've been practicing for 25 years, my practice is solely dedicated to appellate practice, 100%. I'm board certified at Florida Bar in appellate practice. I've been so for about 13 years now. I come, I don't want to go through my life story, but I graduated from law school a week before I turned 40. If you do the math, I can figure out how old I am. I'm not going to do it. So prior to that, I moved down to Florida from New York City in 1992 to finish up my undergrad, which I did at USF, sorry, and went on to law school at FSU. Was the editor in chief of the Law Review, many honors and absolves, wonderful time there. I love doing appellate practice. It's the, or I'm sure it's not what you see on TV, lawyers in a court. I am rarely in a court. I haven't been in, well, actually, the last time I was, because of the pandemic, by Zoom, even though the courts have opened up, we still have the option down in the third district in Miami to do oral arguments by Zoom. I agree with the other side. The last time I had oral argument 2 months ago, yeah, let's do this by Zoom. I don't want to have to get in the car and drive. I'd rather just throw on a suit jacket, sit in my shorts there. But it's a wonderful practice. It's very cerebral. It's the pointing-headed part of the law is my common law profession.
You mentioned you're board certified appellate lawyer. What does that mean for?
It means I took
I know what it means. We know what it
You,
means.
you
Yeah,
know.
yeah,
That means I can use you as a reference for my next term.
yeah.
Yeah, you have to, among other things, you have to, it's a rigorous, it's an exam. You have to take all the exam, you have to take a rigorous application, which you have to show that a certain percentage of your practice has been dedicated to appellate practice over the preceding however many years. You have to list every case you've ever done, appellate case, all the judges who are on the case, and you have to get 3 references from the judges on appellate courts. I've to get research, to get the official certification, to be recertified. And as I said, there's a rigorous exam. It's like a mini-bar, 1-day bar exam on appellate practice. So that's what fortunate. I have a basic handle on appellate practice, more than a basic handle on appellate practice. State and federal court, because this is the state work. This is the state appellate court system. I also practice routinely in the federal system, mostly many bills in certain. In any event, appellate practice is a wonderful thing. It's very cerebral, as I said. It involves a lot of writing. You don't have to be, but you should be a good writer. Enjoy writing and let the law. Wonderful practice. In addition to litigating my own cases at the appellate level, I provide trial support to our trial level litigators, particularly in federal district court, which is a slightly different kind of litigation than state court. It's more writing intensive because the trial courts, district courts, U.S. district courts don't have many hearings, and they decide things based on papers. So you have to write. So I'll provide that kind of support to the trial court attorneys in office. Sorry, I don't want to speak way longer than I should.
Yeah, you're into your rebuttal time.
I can get the reference, and then when I have to recertify it for you,
So my name is Ted Green. I'm a sole practitioner here in Orlando. I graduated from the University of Central Florida. I went into the Army and spent, thank you, yeah, it's a pretty good school. Actually, I have a history professor that I still keep in touch with, and his pride is he taught my father, he taught me, and he taught my oldest, who is getting out of the Army in July. I'm going to go to law school hopefully here in town. But anyway, so I'm a sole practitioner here in Orlando. I've been doing this for about 20 years. And as part of my practice, I represent individual clients. I didn't represent Miss Henry at the trial level. That was a different attorney. As part of my sole practitioner practice, I represent individual clients. They are usually family law clients. So dissolution, post-dissolution, which my oldest, when he was about 12, asked me, what does that mean? And I said, it's for those who didn't get enough fight the first time around. But in this role, I do a lot of, so about 18 years ago, I signed up with a national law firm, Cronin Moss, who litigates primarily these types of cases. They do other stuff too. And I've tried cases for them on these issues, as well as in federal court on debt collection and consumer practices cases. So I was a principal trial attorney, and in that role, like James was saying, I got to write a lot of briefs. And I guess they liked them. Well, I know they liked them. You're always cautious as an attorney, especially a young attorney, because you want to be smart, but not too smart, because the partners in the firm, you don't want to intimidate them. So there were some things I thought I could do to maybe make some improvements, and I was hesitant. One of the partners said, "Ted, if you can make my life easier, go ahead and do it." So I started writing trial level briefs. And the manager for the firm who handles appeals across the nation said, "This guy's not too bad, you ought to use it." So I started doing their appeals as well. So I've handled probably 6,000-ish trial level cases. I've tried about 40 or 50 to conclusion, about 35 of them this kind of case. I do appellate work now too for both Cronin and Moss. Now, I don't want to shortchange the people that are paying me to be here today. My familiarity with Cronin and Moss, I was successful on some appeals. And so when Morgan and Morgan got into this, they thought, let's see if that guy can do something for us. So that's how I got involved. I've represented the firm in a variety of different issues. I've represented them in certain aspects of cases like this. Like you heard me mention, I was the attorney fee expert below. The way it works in Florida is if you want to get fees, you have to put an expert forward. In federal court, they just assume, well, judges used to be lawyers, so they know how it works. But in state court, that would be improper for a trial judge. So they have to hear from other attorneys who do this stuff. And I testified here as a fee expert about the issues you heard us talking about today that would hopefully, we'll see, fingers crossed, support the multiplier. And then because I do appellate work, they asked me, would you like to handle this for us? And I said, yes, because I love this stuff. And that kind of leads to something James said. This is me. I enjoy the trial level. It is, as they used to say in the Army, shooting and moving, shooting. You're trying to take a point and move on to the next thing. You always get something further coming down the road, especially if you're in federal court. And now state court is becoming more like this. They're putting a lot of timelines on things. So you got to be moving like that. So we had a 3-hour hearing here. That's unusual. Usually it's 15 to 30 minutes and the trial judge trying to make up their mind on the fly. But at the appellate level, you really get to flesh things out. And as you saw when we came here, you have the judges that have typically read things and they know a lot. And also the neat thing about the appellate world is there's a lot of nuance to it. In the earlier appeal, the appellate, one of the panel members, I think Judge Cohen, said they're not required to defer to trial judges because they're in just as good a position to decide what the law is. Actually, there are some Florida appellate decisions that say the reason that appellate courts don't defer on legal issues is because they're in a better position to know what the law is, because that's what they do. Trial court's job is to apply the law. The appellate court's job is to decide what the law is. So I like both aspects of it.
Well, let me ask you this: when you become both of you, when you become aware of who the panel is, does that affect how you present your appeal? Because there's 11 judges on our court. We 3 are the ones in this case. Does that affect your presentation or how you present a case?
So sometimes marginally, like I did another law day presentation as well before this court, not this panel, but this court. And Judge Bruce Jacobus was on that panel. Is Judge Jacobus? No, I'm sorry. Okay. So there, Judge Bruce Jacobus, who used to be a trial judge in Brevard, I was in front of him quite frequently, and we had developed a rapport. Now, Judge Evander, I believe, was on that panel as well, but I don't think I had ever been in front of him as a trial.
He's a tough guy to develop rapport with. So.
Yes. But Judge Jacobus, I knew his personality. So in that other appeal, I actually framed my argument in a way that the other side would look absurd, but it wouldn't be insulting, it'd be humorous. And it got the reaction I thought it would get. Judge Jacobus kind of slapped the desk and started laughing. And that was kind of the feel I hoped I would get. I've been in front of Judge Cohen many times, although he may not remember, it was years ago. He is always a very serious guy, so he's not the guy you come in and you start telling jokes with. So it does to a certain degree, but although he's an excellent judge, and I've always
Almost forgot that part. didn't you?
So a little bit.
Good looking.
Good looking guy, good looking guy. So a little bit it does, but to a large degree, really the thing driving my argument is that guy right there. Now,
Not me personally, but
right,
who I represent,
Right, and
the other side.
yes, yes, and I was actually going to say that James and I have never litigated against each other than this case. But there are some attorneys on the other side. I know their personalities, and let's just say you tailor your argument for legal as well as personal weaknesses on the other side. But James, I knew nothing about, so I just knew I had to come in and do the best I could.
All right. Thank you. Well, let's ask any questions from the audience, from the students?
I have one for Mr. Wine. You obviously entered law a little later in life. Was it a second career for you? And did you find your life experience helped you go from law school and in practice once you got there?
Yeah, actually, it was at least a third career. I was an assistant buyer and a group manager for Kimball's department store in New York for a number of years in the early '80s. Then shifted gears, went to the Institute of Audio Research, got a multi-track recording certificate. I was a recording engineer, producer, and artist for a number of years until '92 when I said, you know what, I want to go. It's actually after the Clarence Thomas and Nina Hill. I said, boy, these people are fast. All these people are fascinating. I'd like to be a lawyer. My stepfather was a law professor at Rutgers. My mother was a mergers and acquisition lawyer at Skadden Arps in New York. So I had it in the blood, and I realized at that point in my life, I was 34, so I realized, hey, I can do this. This is really interesting. I can't see myself being a recording engineer or, producer, whatever, at age 50, going out to clubs and things like that. Now, well, beyond age 50. Certainly couldn't see doing that. But I didn't, I said, let me, I'm a right guy at the right level. Let me apply myself to, I had to go back. I only had 3 college credits at that point. Moved down to Florida, went to what's now called State College of Florida, which at that time was called Manatee Community College. Transferred to USF, their Bradenton, Sarasota campus. I got it at FSU College of Law, and the rest is history. So yeah, it has informed my outlook because I lived the first 4 years of my life as a non-lawyer. So I see things from a slightly different perspective. But again, the law is the law, and I don't respond to the earlier question. I don't tailor it to a particular panel. I mean, there have been a number of cases. I've been before panels where I know personally the judges before they became judges. Judge Barbara Lowe was from the 11th Circuit. She was a good friend of mine from when I was an associate with her. I had appeared before her a number of times. She was on the 3rd District Court. Full agree with. I was a clerk with her at the 3rd District before. So, but I don't tell my arguments to orders on the panel. I mean, I've been before Judge Cohen and Judge Lambert for 3 years. So I'm not often. But I don't. It's the law is the law, and you just apply your best effort to argue on behalf of your client that this is what the law says and why it favors that client.
Is there any truth to the rumor that John Legend owes his career to you?
Actually, I think he was probably in grade school when I left. So yeah, but the Run DMC and all that, that's the studio, those 80s folks. So, but yeah, I did. That was it. And to answer your question more directly, I mean, it really doesn't. I mean, I have much more life experience than your average. I'm old. But it doesn't really. I mean, it was like a shift in careers that had nothing. What I did, retailing as an assistant buyer for Mrs. Coates and Susie Gimbels and Hellsfield, and as a recording engineer, it really has no bearing. I mean, it's just life experience. It's a big part.
I share that.
You're good. You're not 22.
Some I always wanted to pursue a career in law, and coming to the table in my first career, retiring from Disney. I really wanted to do this, and I woke up one day and decided it was time to make the change. And I went back to college, and here I am.
Good for you. Good for you. And it's amazing when you go back to school later in life, you have, I mean, when I originally, I started off at Syracuse University in the mid-1970s, and I had a great time, especially really. But that's when I was 18, I was on my own, so, and I just, my father said, I'm not paying for you to go to school, buddy. So I had to make my own way. And the thing is, when you go back to school, it's not more serious, you realize that.
Well, I was more serious.
Yeah, you realize what's at stake, you apply yourself.
Yes, ma'am.
I'm just feeding off what you said about being a good writer. Is it something that like came natural to you, or like was it something that you also had to work on? So like when you first like start doing briefs and everything like that, I know there's like the first introduction of trying to learn the format and all that. What helped you get to where you are as like getting better at writing and being exactly to the format that's needed?
Yeah, that's an excellent question, because I read a lot when I was young. I was a hopeless romantic, read a lot of F. Scott Fitzgerald, Ernest Hemingway, Thomas Wolfe, just read a lot. And that, reading a lot, and read the New York Times every day, reading a lot, reading other good writers, that imprints, I believe, your mind with this is how you write. It's like exactly how you write. You have to have a degree of creativity format. But that, and actually writing so I started journal, and I just developed it into a decent writer, a good writer. By dint of the fact that I've been very supportive parents, they're well educated. I took Latin for 5 years in my school. I guess that helped too. But I didn't seriously, at one point I wanted to be a copywriter. Actually, 40 years ago, more than 40 years ago. That I thought, well, you have some talent for writing. But it wasn't until when I was a reporting engineer, I was asked by one of the Village Voice to do a freelance piece on and current reporting process, which involved media and sound and that kind of stuff. What a very lengthy piece on it. Well, you can probably do this for a living or something. And it all of a sudden clicked. One day when I realized,
Counsel.
do this in the law. You could be, not that I grabbed wildly creative appellate briefs or anything like that, being snide, making jokes like that. It's pretty broad.
Thank you.
Count.
Yeah, I'm sorry.
We had two other attorneys. We're talking.
We'll adjourn to the bar.
Yeah, well,
So come on, guys.
Very well argued case. We appreciate everything, and we appreciate your willingness to spend and share time with our students here. We do have one other case to let those attorneys are chomping at the bit, probably ready to go. So we do thank you very much, and have a good day. Have a safe trip back.
Thank you. Thank you.
Okay, third and final case this morning. It's a criminal case, shifting gears this morning. So this is case number 21-735. Brian Shane Teague versus State of Florida.
20 minutes per side. So, Mr. Wurtzel, whenever you're ready, you can proceed, sir.
All right, good morning. Thank you. May it please the court. My name is Ben Wurtzel and I represent Brian Teet, the appellant in this matter. I'd like to reserve 5 minutes for rebuttal if I could, please.
Very well, sir.
So there are 3 issues that we raised in our brief, and the first issue and the issue which I would like to focus my argument primarily on this morning is the first issue in the brief, which is that the trial court erred in denying Mr. Teet's motion for judgment of acquittal. Specifically, the trial court erred in denying the motion, finding that Mr. Teet stood in a position of custodial authority at the time of the incident in count 6, which is the only count for which Mr. Teet was convicted of the 7 charged.
So he was the ROTC instructor, was he not?
Yes, he was.
For the 17-year-old student who he had sex with.
Yes.
As found by the jury.
As found by the jury.
Jury that he
as to
committed a
count.
sexual battery upon the 17-year-old victim.
Yes.
Okay.
Yes. And so, for that reason, this court should reverse and remand with instructions to enter a judgment of acquittal in favor of Mr. Teet. Now, I think it's important to frame the issue at the outset that the statute here, the operative statute, does not define custodial authority. It doesn't actually define familial or custodial authority.
Nor does the jury instruction.
Correct.
Okay. All right. So you all asked for and received an instruction based upon case law. So what does the case law say in terms of defining custodial authority?
So the way that the case law suggests that custodial authority should be defined, absent a statutory definition, is that it should be, the court should first look to the plain and ordinary meaning of the term as it's used in everyday language. And the Florida Supreme Court in the Hallberg case, which is the primary case upon which we rely, specifically identifies from Webster's dictionary. And what it provides is that a custodian is somebody who has custody of another, and custody is defined as a duty or obligation to care for another. And concerning a child, that's where the phrase in loco parentis comes in. Essentially that somebody is acting in place of the parent in terms of providing care or supervision for a minor child.
And it talks about factors that are considered. Like,
Yes.
did this event happen? Did this incident happen during the school year?
Yes, this did.
In Hallberg, it was summertime. Here it was a school day.
Correct.
All right, but it was not on school premises.
That's
It
correct.
occurred at where the 17-year-old was living with her grandmother at the time.
Yes.
All right, so and that's a factor that favors your argument here that it was off school premises.
Yes.
So following that, so if it was an after school class or the ROTC class, after school activity here, if they had sex in the classroom, your case is more difficult?
Absolutely. And the reason that I think that that's an entirely different question is in order for somebody to be acting in loco parentis or have care or custody for a minor child, that can be really done in 2 ways. And I think that's the crux of this
So
argument.
if it's after the class is over, that it's on the campus, in the parking lot on the school campus, then that would still be problematic and your argument would be more problematic?
I think it is more problematic. And the reason is that there's an idea that a child, while at school or on school premises, that there's an extra duty to provide care for that child. However, that's specifically even more so, which we don't have here, if in the event that it were to happen during school hours or during a sanctioned event.
So let's say that the instructor, they go to his car, she's there, and he drives 10 feet off campus and they have sex. Now they're no longer on school premises. That a defining moment? That's a significant event that would favor your argument that it's not on school property?
I think in that specific instance, I still think that in that situation that he would not be in custodial authority over the child at that time, unless he had specifically been asked or by a parent or guardian to transport that child home. So I do believe that once you leave, if he had been tasked or charged with getting the child home and that were to happen before that's effectuated, so to speak, before they arrive at the house, then I think that becomes a much closer question. However, without any consent or knowledge from the parent or guardian, in this case, the grandmother or mother, I think under that specific incident, I do not think that he would have been in custodial authority at
You
that
seem
time.
to make significant that your client did not receive consent from the grandmother or the mother at the time to
Yes.
take the child home.
Yes.
Now, if he had received consent 10 prior times and then the 11th time he just forgot to ask, but he drove her home as he did all the time, that specific day, not getting the express consent, that's a telltale sign that it's not a custodial scenario?
Well, I think it's important to note the difference here and specifically what was the mother's testimony at trial, which was that this is not a situation where he commonly took her home. She indicated that she had given permission, and when I say she, I mean the victim's mother had given permission to Mr. Teat on 2 prior occasions to drive her home, and that she testified specifically that she did not do so on this particular incident. And I think that that's important because it does show, when we raise this both in our argument and our brief, that the mother controlled that aspect of the child's life, and that it was clear that permission was needed to in fact take the child home from school or after ROTC practice. So this wasn't a situation where he commonly drove the person home. And one thing that I would note too, to kind of address that situation, is one of the cases that we cite is the Cruz case, which is from the First District Court of Appeal. And in that case, the defendant in that case had repeated contacts with the child, and it states that the custodians, which were the grandparents in that case, knew that Mr. Cruz was routinely driving the child to school, that they'd gone to a car show together, they'd gone to a storage shed, and that they were in routine contact together. But on the—
He wasn't the teacher though.
Well,
He wasn't the victim's teacher in that case.
well, he had been the victim's teacher. He was the charged incident occurred over the summer. But what's interesting about that is it specifically states, and they note in that one of the key factors there is that this happened at the home without them knowing, without the consent. I also think that the Hallberg case is instructive there. In Hallberg, the individual's parents knew that Hallberg was who had been the child's teacher, and actually in the Hallberg case below, in the second district, they actually expand on the facts, and the child had been signed up to be in that teacher's class next year. But also during that specific summer, that teacher in Hallberg, the parents were aware that that he was helping with a project. They were aware that he was, that they were meeting several times, and the Hallberg court specifically notes that the issue is that the charged conduct took place at the home when the parents were not present and when they did not know about it. So I don't think that just because there had been a prior grant of permission, or that it was known that there was prior times when Mr. Teat had driven her home, I don't think that those are determinative of the specific issue here.
If there's a general rule from Hallberg, it would be that teachers are not custodial authorities in custodial authority by nature of the fact of their profession, correct?
That's correct. And so the question really becomes, I think, the crux.
Let me ask you this.
Yes.
In Hallberg, the event occurred over summer recess. Here, the student could still have their grades affected arguably by how the teacher perceived him, because she was a student at the time of the sexual battery. Hallberg also refers to custody and control rather than custody or control. So does the fact that she's still a student, does that affect our interpretation whether custody existed? Does it affect control? Does it affect either one?
So I think the issue there is that, and it's important to note that you're correct, that Hallberg says custody and control. And very recently, the second district in the Woolman case builds on that and says, yes, they specifically address that and say that it is conjunctive, or excuse me, that it requires and, it's not or. And so the idea there, and I think this is while I was not trial counsel, I assisted and did argue this before the trial court. I don't think that the trial court and the state below understood and how that distinction applied in this case. And the reason being is those factors that you mentioned really go to the aspect of control. Do you have the power to potentially exert power over somebody, or what could your effect be over them? But there's a separate requirement of custody that the state simply did not present any competent, substantial evidence. So while this occurred during the school year at a time when Mr. Teat,
And so then I take it from that argument that you implicitly would concede that there would be sufficient evidence to establish control, but your argument is based upon the definition of custody.
I think that there are, that based on Judge Evander's question, that there are certain factors in an argument that a person could be exerting control over somebody, more so in a time where they are in their classroom or they are their instructor. But the focus again is that there's a separate requirement of custody that simply there is no evidence of in this case.
Was that a yes?
Well, it's whether or not there was control over this person in terms of the ability to exert influence over them, I think is a very subjective question.
Isn't that a question of fact for the jury?
The control may be a question of fact for the jury, yes. The custody is not, because there was not competent, substantial evidence of both.
So if Mr. Teat had asked grandmother or mother on April 16, do you mind, is it okay if I take your daughter or granddaughter home after ROTC practice? And one of them said, yes, that would be fine. Thank you. We appreciate that we don't have to drive now. And then this incident happened.
So
Then he had control. He had express consent to have custody over her vis-a-vis transporting her from the extracurricular activity of which he supervises to the house. Does that become becomes extremely problematic to your case here? That seems to be one of the highlights, that there was no express consent. So
correct. So in that situation, if you're asked about consent, I would say this, that it becomes a much closer call, because then there's an express condition. Now, there is still a separate break where, again, the line has to be drawn somewhere at some point.
apparently at the school boundary is what you're doing.
Well, the point being is, if the consent that he's given to have custody of this child is to take the child home, what I mean by that there's a separate break is, in this point, it may be that you get the child home and then you then go inside and.
So if they have sex in the car, it's a sexual battery. If they have sex in the house, it's not.
Under the specific question asked by Judge Lambert, it would be our position that under those facts, yes, that if it were to occur in the house and that there was no agreement with the parents or no express consent to enter the home when nobody else was there, that the custodial line, so to speak, is completed once bringing the child home is effectuated. I do recognize that is a closer call. I do recognize that. But that's
So if
simply.
we write an opinion, I mean, if somebody reads this opinion that says, just make sure if you're going to be one of these people who are going to commit these type of acts here with a 17-year-old, don't ever ask permission to take her anywhere.
Well,
Because that becomes problematic under what you're saying under Hallberg, that becomes, now you have express custody over my minor child.
well,
For that purpose, that
sure.
time period.
Sure, but my response to that would be, this court's opinion, were it to find that, would be no more than anybody would say, well, what Hallberg tells us and what Cruz tell us is, if you're going to have a romantic relationship, fine, just wait until the summer, then you're good to go. That's why I don't think that argument or that concern is there, because there has to.
Or make sure you get off campus by a couple feet, and then you're.
Whatever the
you have a
specific
better-
factors
you have a
are.
better way of avoiding a criminal prosecution.
The bottom line is that there has to be a point where custody of the child ends and the parental responsibilities resume. Now, where that line is drawn depends on the particular facts in the case, But in this,
Well, the facts of this case is that he knew that the grandmother was out of the country.
correct. Well, correct, that she was in Puerto Rico. Right. And so I think that that actually supports the argument that it's there, that it couldn't even be argued that, yes, there was probably permission to
Who's he
go
gonna
in.
ask? I mean, he's, I've taken her home, I've taken her home, I've taken her home, and now grandma's out of the country here. And so there's nobody for me to quote unquote ask, so I'm gonna take her home like I've always had the consent before. And then this incident happened, and now he's saying, well, I really didn't have custody over her.
And I see that I'm into my rebuttal time. My brief response to that is, again, there were only 2 prior times, according to the victim's mother, that Mr. T drove the child home. And during those times, both times, it was with the express permission and consent of the mother per her testimony. So I think that when you have those facts, it then follows that without that consent and knowing that nobody's home, that this is just a different situation that does not fall under that.
I know you're in your rebuttal, but as a follow-up, on those 2 occasions, was there also permission to go in the house or not? Or was it just to drive my grandma?
So the question that was asked at trial was, had Mr. Teet ever driven her home before? And the mother's answer was yes, he had done that on 2 occasions. If I recall, there was no specific discussion about entry into the home other than that nobody was home and nobody did get permission to do that.
Thank
All
you.
right,
Thank you.
When you get back up, I'm going to want to discuss lesser included.
Yes, sir.
May it please the court. My name is Richard Palace. I represent the state of Florida. The trial court correctly denied this motion for judgment of acquittal. To go back to the Halberg factors, importantly, the court approves the dissent and specifically the analysis by Judge Altenburn out of the Second District Court of Appeal. And in closing this actual analysis, they said these liaisons, while reprehensible, were so far removed from both time and place of his responsibilities as a teacher.
Let me ask you this.
Yes, Your Honor.
Halberg obviously is the critical case, but can you explain the rule of lenity?
Oh, yes, Your Honor, the rule of lenity is built into our statute of construction, I believe under section 775.025. I'm probably wrong there, but it involves our Blockberger analysis and a lot of canons of construction for statutes. The rule of lenity is essentially if a statute has an ambiguous term in it for criminal defendants, they will typically be, it will then be evaluated in favor of the defense. Typically.
In this case, the statute has no definition whatsoever of custodial authority, and there's no dispute in this case that there was no familial position of familial relationship. But so we're dealing with custodial authority. It's not defined in the statute. Why then, under the rule of lenity, should the benefit of any analysis not go to the defendant?
Well, first, Your Honor, while obviously this wasn't briefed as much, of which the state can certainly do if this court so requires, that canon is now in recent case law looked at as more of a canon of last resort. We typically start with, the plain language of the statute, reading the statute along with other terms, and then looking into ordinary meaning, typically through dictionaries, as the Florida Supreme Court did in Halberg. So to that, I would say that we would not resort to that canon of last resort at this time. And of course, the court, the Florida Supreme Court did define this. And of course, our district courts of appeal have followed this definition.
Will you agree that under Hallberg, we need to examine both custody and control?
Yes, Your Honor. I believe this court has also followed that concept.
And so the big issue here is probably custody, right?
Yes, Your Honor.
Okay, so if a teacher has a student in their class and they run into that student at the mall and happen to, go to some place out of view and have sex in the mall, you have custody.
Your Honor, I do not believe that would be custody, no.
Okay. So help us draw the line here. If they're at her house, not his house, her house, and the parents and grandparents have no knowledge or consent, how is that different than the situation of running into the person at the mall? What if instead of him driving there, what if she, took the bus home and he drove to her house where she was residing after that?
Well, Your Honor, I believe the state would have a much harder time proving that. I think in that situation, when a student leaves the school, I believe you're no longer acting in loco parentis, the Latin term that was brought up, obviously, both below in arguments as well as in the Halberg case and its progeny. What I think is important is that this whole concept of in loco parentis, it's when you're in the shoes of the parent. When your child goes to school, you're expecting, they're in custody of the teachers while in the classroom. If that teacher happens to supervise an extracurricular activity, something absent from Halberg and Cruz, then you would expect they are once again in custody of them. Now,
If the activity ended and she went home, got home 10 minutes later, and then he drove separately and got there 10 minutes later, you're agreeing that there's no custody there, is that right?
yes, Your Honor, I believe that is just a much harder case for the state to
Your
prove.
critical factor is that he drove her there.
He did not break this. I know that this is a term used in far different reasons for criminal law, but he did not break this chain of custody, if you will.
Okay. Well, your opponent's position is that there's another step, and that is going into the house. What's your position on that? Is that a break in custody?
Oh, Your Honor, I believe that if he went into the house and obviously a parent is home, it breaks that. I think that the shoes don't come off in this metaphor, you wearing the parent's shoes, until you have either he leaves, or if he happens to hand her off to one of her guardians, her mother, whoever would have been home at the time.
What case law do you have to support that proposition?
Your Honor, I'm basically pulling this out of just my application of the Halberg factors. We have yet to, I think, have this situation where it happens directly after an extracurricular activity with a defendant who happens to be this close to the actual victim, someone who texts her all the time, someone who's been giving her gifts, someone who happens to be confiding in her certain personal details, such as issues with his marriage, someone
Would it
who,
make a difference if none of those factors were involved?
I think that without all of those factors, because that's context into this relationship developing.
Those factors define the drive.
Oh, no, Your Honor. I think here that our factor of the drive is primarily defined of the fact that if a teacher's driving my child home from school, they're responsible for my child taking them home. If my child is a latchkey kid, runs off into the house, and then he leaves, I believe at this point we draw that line. But by him coming into that house, he's remaining this authority figure to her. Unfortunately, in the victim's case, he remained an authority figure that wished to have sex with her.
It's an issue of control. It's not an issue of custody, right?
Oh, I think her being in his car is the issue of control. I think the fact that he is this authority figure who is, it's almost more of, in my head, a force field.
Under that theory, Hallberg was decided wrong because Hallberg says you're not in custody by the mere fact that you're a teacher.
It says you are, well, specifically that finding is that teachers are not at all times in custody. And that is particularly, and that's language specifically from that case, particularly during the summer recess. Here, we're not in a summer recess. He's taking her home directly after something that he supervised, which is either her volunteer opportunities or the training that they do for the JROTC, for something of which that her future very much relies upon doing well at. I'm sorry, I lost my train of thought for a second from that before I allow myself to drift away too far.
All right, let me ask you this. Not too long after this incident, the legislature enacted a statute which kind of, I don't know if it's in response to Hallberg or not, but said, hey, if you're a teacher and that's a present student, no sex, no romantic relationship at all, doesn't matter where it is, et cetera. Do you think that statute is in recognition of the possible gap that Hallberg caused, or?
I wouldn't say it's in recognition of a full gap for any teacher who has left the campus. I would say it's in recognition of a gap of that a teacher might have happened to have, oh goodness, I do not want to use a metaphor that is too misguided here, but a teacher might have flirted with a student, let's say in the 9th grade, and then he is no longer her teacher anymore come the 11th grade, but they still reside at the same school. If they then have sex afterwards, that's a case that we can't prove. I mean, that's not the facts we have here, but I believe that if he's not her teacher in the 11th grade and this doesn't take place at school, under the Hallberg factors, that doesn't qualify. I believe then Hallberg factors would be superseded by statute if the legislator did such a thing, Your Honor.
One of the things you suggest in your brief is that if we are inclined to reverse as to the custodial issue, to send it back with direction to impose a judgment for a lesser included offense. Now, the only lesser included offense that was actually given below a trial was simple misdemeanor battery.
Yes, Your Honor.
I mean, although it is a category 1 under that, I mean, it's still, it has to be an unconsented touching. And here, the 17-year-old said, no, this is completely consensual.
Well, Your Honor, I believe that battery also has the misdemeanor battery specifically has the alternative method of charging. I know it's, I mean, that's our only category 1. It was of course requested, but I know it's intentionally touching the victim against their will, or I believe it's also intentionally causing bodily harm to the victim. And in this case,
Well, that's a category 2 lesser.
Oh,
Subparagraph 2 is a category.
Oh,
2.
that's correct, Your
That's
Honor.
a permissive.
It's but the jury
Well,
was.
there's no harm anyway. Did she say she was hurt?
I believe she was never testifying to it hurting or anything. She, you know, there was very much just stating what happened on the
Right.
date or the time
So,
frame.
but my point is, it doesn't seem like battery falls in. What other lesser, were you referring to some other lesser included that we should send it back to?
Well, of course, here, Your Honor, I believe the state is for the most part restricted to just what has been requested as the lessers.
Okay.
Now, I would love to make an argument beyond it because there is the concept, Your Honor, that the crime of in sexual activity with a minor has very much the same exact factors of which that the jury made a finding for. That being said, this was not requested by the state. It was not requested by the defendant. In the case law interpreting section 924.34 seems pretty clear that it has to be presented to the jury for it to make the factual findings. Now, that being
And the
said,
state arguably could have charged that initially, but they chose not to, right?
that is my understanding, Your Honor. Obviously, I cannot speak for the state's decision as to why they would charge things a certain
Well, I
way.
mean, it wasn't in the information that was filed, the charging document.
Oh, yes, it was not charged as a separate file. I mean, you could, of course, look through the information and still find the elements of sexual activity with a minor, because in that case, of course, it's between, I believe, 16 and 17. The defendant has to be over 18. We're talking about sexual penetration or union. And then, of course, the same concepts of custodial or familial authority. Why that was not charged, of course, I cannot speak for the state, Your Honor. And again, the state concedes that that was not requested as a jury instruction. There was not an alternative charge in the information specifying that statute.
So then what was your point in your brief about a lesser included?
It would have been.
I know that the battery, that there wasn't evidence of a, non-consensual touching.
Well, Your Honor, the state was mainly going off of the evidence of the bodily harm. And while the victim did not testify to that, we do have the nurse practitioner who had done the sexual assault kit, of course, saying that there was bruising that was consistent with sexual assault. We have the state's.
But that's consistent with consensual sex as well, is it not?
That is correct, Your Honor, but of course, consent.
How can that constitute bodily harm?
I mean, just looking at the way that the statute reads, Your Honor, under the alternative form of charging under the other subsection, just the fact that there's consent is not a part of that one in bodily harm. It is for the first part of battery, the intentional touching. I believe for the alternative form, the consent was not required, at least the way that I read the statute, Your Honor. Of course, the state does recognize it's not the best of arguments. It's just there's no harmless error in this concept of the judgment of acquittal in this case. So for us, that.
So two people can get in a consensual fist fight, and then the one who's ends up the worse for wear could then see if that could be prosecuted saying, well, I know I consented to get in a fight, but I really got beat up more than I thought I should, and it really hurt, so I would like you to charge it with battery.
Well, I know, Your Honor, at that point, we would definitely lose with the consent defense in that
Okay,
case.
well, I mean, that's kind of the point, is that you can't, they're linked.
The state certainly acknowledges that, Your Honor, and we know that, of course, this is the weaker argument of this, but the state is very confident in the fact that this person was in custody and control. This case is further from Cruz and Halbert. But if this court does not have any other questions, I will rely on my brief, and I ask that you affirm.
All right. Thank you, counsel.
Thank
Mr. Wurzel, you're 3:38 according to magic clock here.
And Mr. Wurzel, you do not have to address the lesser included.
Okay.
I think we've covered that.
If you recall that he asked you that before.
He did, and I was going to, my first question was going to be whether or not we needed to revisit that. Okay, I think the state has conceded that. So one thing that I would like to point out is the state focuses its argument that this case is not like Hallberg and it's not like Cruz because it didn't occur in the summer. That's a fact that we understand. However, the idea is not, again, that it happened during summer. The idea is it removed from a school activity, a school recognized activity? And one thing that I think is important to consider in Hallberg is that although Hallberg happened during the summer recess, you have a former teacher who is going to be a teacher. And specifically, the reason that Hallberg was there during those repeated times was to assist the student with a school project. So I think that Hallberg is actually more connected.
Isn't it though really get back to the express consent? Because you're not saying the fine line is that when the extracurricular activity ends, the softball game's over, or the ROTC class is over, that if no sex happened during the class or the game, and it happens after the fact, that's not a problem vis-a-vis the criminal charge being brought against you. I mean, your scenario is he took her off campus back home and she did it without express consent of the grandmother or mother. Therefore, he really didn't have custody. He didn't, quote, have the stereotypical custody over her vis-a-vis how teachers have in local parental custody when their kids are in the school.
That's correct. And I think one thing that's important to note is that Hallberg specifically in rejecting the three arguments that the second district relied on in the lower opinion, specifically rejected the idea that closeness or a bond between the two was determinative, because in the Collins case that it references, it specifically says in that case, it was done though without their knowledge and without the consent. So the issue again is that on this continuum, there has to be a point where custody is vested in another person. And the state in its answer brief says, all right, well, the appellant's argument is then that that the statute requires express consent, and that's not what we're saying. There are many times when there would be implied consent when that there's an idea that when you send your child to school or your child's at ROTC practice, that the school, the county, whoever it may be, is going to be in charge and caring for the child. However, there has to be a point when that goes from the kind of implied custody that is vested on somebody else to care for your child, and then parental responsibilities resume. There has to be a line.
So does the ride home, is that dependent upon whether there was consent or lack of consent to give the child a ride home?
It's our position, yes, that it does. And that, again, that there's also a further step there of then once you're home of going into the house. And again, this is what, well, I think it's important to look at the facts in Hallberg, where the purpose of being at the home was for to work on a school project, a school related event. by all indicia here, the purpose of going inside, there was nothing really testified to other than to go inside to have sexual relations. So,
And the invite into the house came from the victim.
that's correct. She invited Mr. Teat in, and I see that my time is blinking.
Would your client be in a much more difficult situation if the state had also charged under one of these sexual activity with minor statutes rather than relying solely on custodial authority?
Then there would, yes, there would be a completely different consideration. However, I think that as been noted, one thing that I would point out is that in this particular case, actually all the elements have not been proven, and that in sexual activity with certain minors, which is a separate charge, which addresses 16 and 17-year-old children, explicitly one of the elements is the defendant's age being over 18. In this particular case, Mr. Teat's age was not charged in the charging document. It was not instructed to the jury, and the jury did not find that. So while the court can instruct on certain remand for certain permissive lessers, that is restricted.
I don't think Judge Evander is suggesting.
Yes, that would have been a different,
He's
that
saying
would have been a different question to
They
answer.
chose poorly when they did their charging documents because there had following your argument, there was a possible better crime they could have charged Mr. Teat with that may have been more easy for them to prove than.
Yes,
I know you don't want to concede that because you client.
I'm generally not in the business of advising the state how to best charge my clients,
No,
but you're, yes.
No, obviously, but we all kind of see here that
My answer to,
they charged him with that. Custody's an issue, but there were other, nobody's condoning obviously the behavior, but there was another crime that could have been charged here if the prosecutors below had perhaps thought it through a little bit better.
there could have been.
Right.
Thank you.
Thank you.
Okay, gentlemen, you want to introduce yourselves to our audience?
Sure. All right. Good morning, everybody. My name is Ben Wartzel. I am a criminal defense attorney. My office is in Winter Park, Florida. I own the law firm with my law partner and wife, Lori, who is here today. She's the brains of the operation. So if there are any technical questions or anything that an educated person would need to do, I'm going to defer those to her. A little bit about myself. I went to the University of Florida. After graduating from the University of Florida, I went to law school at Stetson, which if any of you are considering a career in law and specifically think you might want to do trial advocacy, Stetson has an excellent program for trial advocacy, both trial advocacy, appellate advocacy through the Newport programs, and living in St. Pete for 3 years is not bad either. After law school, I went to work for the public defender's office in the 9th Circuit, which is right here in downtown Orlando. I was there for about a little over 7 years. And then in March of 2018, I left the public defender's office and we opened up our own law firm, which is a private practice in Winter Park, Florida, where I practice exclusively in criminal defense law. My wife is a co-owner. Her background is in criminal defense. It's also an education. She practices in criminal defense law, also does some family-related matters, appellate post-conviction work as well. So I'm happy to answer any, and I am board certified in criminal trial law. I was first board certified in 2016 and then recertified last year in 2021. So I'm happy to answer any questions that I can. Yes.
In dealing with criminal law, are there some things that you see that bother you past trial? Like, you ever feel like maybe you have to go talk to someone or whatever with what you might have to deal with it?
So that's a question that I get a lot. My answer is no. Now, it certainly can be stressful. There's no doubt. I think practicing any type of law is stressful, but criminal defense litigation, especially when you're representing the defendant in a criminal case, it's undeniable to some extent you're holding somebody's freedom and liberty in your hands. So there's a lot of stress that comes with that, but I think the key is to always do the best you can to be prepared. That reduces some of that. And then in terms of seeing things that maybe factually are disturbing or things, I'm able to do this, I think, in part by being very objective And that's how you have to look at it. There's factual situations that occur that are extremely unfortunate. And it's natural to feel something from that. But it is something that that you have to be able to put aside. And certainly, I think there could be people who are excellent advocates for criminal defendants who also, do need to talk to people a lot, that they do have to have an outlet for that. Unfortunately for my wife, she gets a lot of that outlet. She gets a lot of that stress that she deals with that, but it's definitely something that I think is a personal consideration. That it's definitely something you should think about if you want to do that area of law, that type of law. Yes.
What made you want to go from prosecution to defense?
So I worked at the public defender's office, which was defense. So I started in defense. I actually started my career, I clerked at a larger commercial litigation firm and started briefly. And it took me all of about 5 seconds to know that commercial litigation and insurance defense work was not what I wanted to do. So I really enjoyed the trial advocacy courses that I took at Stetson. I had some colleagues that were both at the state attorney's office and the public defender's office. But I decided that I wanted to go to the public defender's office and went there not knowing how that would go, how that would transition from kind of the civil and commercial litigation background to that. And I ended up really enjoying it. And I thought when I went there, maybe I'll be here for a year, maybe 2 years. We'll see. I ended up staying there for over 7 years. It was that is the, fundamental block of my career.
Let Mr. Palace have a shot here, talk a little bit.
Thank you, Your Honor.
I guess.
All right, what do you,
Thank you
you
as
can
well.
get back up there.
Apologies for turning my back on the court.
Okay.
Good morning, everyone. I'm Richard House. I'm with the Office of the Attorney General. Our particular branch represents the state of Florida in criminal appeals. So either someone has entered a plea or someone's been found guilty. We are there for what you would almost look at as sustaining convictions, solely focused on the law here, with whether there was error below. They also actually handle appeals themselves. Sometimes the state has evidence suppressed, sometimes the state has its case dismissed, and the state wants to go forward. And so the state tries to say that there's been error in that respect too. So we're not always the respondents in these situations. I actually am a fellow knight to all of you. I got my English literate degree. Well, clearly I don't know how to spell literature, so I don't know if I did so well. But I got that degree knowing I wanted to go into law school because I knew that was a very helpful undergraduate degree prepared for that school. I then went over to Barry. I graduated 2016, passed the bar 2016. I spent 3 years as a trial court law clerk. They're also called staff attorneys. I worked for the 7th Circuit. They're over in Daytona, just down the street from your honors right here. And I watched their website every Friday to make sure I was doing things right. Because to me,
That's what he's referring to, is we release our opinions on Friday, so he reads our opinions. Not like we do something magical Friday.
the magic's for Disney World down the street. The magic's also for Bike Week in Daytona.
Better than Tuesday.
Oh. We get that too. But nonetheless, if you don't yet know what you possibly want to do in the legal field, being a law clerk can be a great opportunity, not just for the trial courts. You can work, as you might have heard the judges state, I believe after the first argument, they have law clerks as well. There's a central staff that's in the 5th District Court of Appeal. All the District Court of Appeals have these support staff. And of course, the Florida Supreme Court has them, and the federal courts all have them, going all the way up to SCOTUS itself. And then after 3 years, I was very fortunate to get hired at the Office of the Attorney General doing criminal appeals. We actually have just opened a branch here in Orlando now, and we've just started hiring for it. Of course, you all have to go through law school first, but if this is something you're interested in, know that you don't have to drive to Daytona to do it at this point.
You're gonna have to drive to Lakeland.
Hey, Zoom is getting very creative here.
Judge Cohen is referring to the legislature has decided to create a 6th District Court of Appeal, which is going to be headquartered in Lakeland, of which 5 of the judges presently on our court are going to be transferred to the 6th DCA. And he's one of them.
Well, necessarily, of course, I know that while Lakeland was always supposed to be headquarters for the 2nd District Court of Appeal as it's currently set up, Your Honor, the branch for the Attorney General's Office for Criminal Appeals is out of Tampa still. Of course, most of the arguments happen in Stetson, is my understanding, is how the 2nd is back. So there's still the possibility you'll handle stuff here. I can't speak for that. That's why they pay me the mediocre bucks.
All right, thank you. Any questions of the attorneys or us? Yes, ma'am.
Hi, good morning.
Good morning.
So I have a question regarding the case. And I'm directing it to both attorneys and your honors. So if this person was a tutor and not an instructor at school, would they get the same consequences since they are kind of an instructor? What do you think?
If he was a tutor, I mean, the issue is whether he has custodial, if the tutor has some custodial authority over the 17-year-old. And whether it happened on campus during activity. I mean, if the school has sanctioned the person to have some kind of authority over these students.
I mean, you're going to hate this. You're going to hear it all the time in law school, but the phrase "it depends" comes up a lot. As Judge Lambert said, we might need more facts for this. If this tutor was far closer to the family, there's the possibility this tutor could be in a familial context, especially if, let's say, this person happens to spend the night over with parents' permission over at the tutor's house, as shown in some of the cases cited in the briefs. Like
when I was a first-year law student, one of my professors, University of Florida, would comment, "The facts make the law," which as a first-year student, I thought, what the heck is he talking about? I mean, isn't the law is the law? And what do you mean the facts make the law? And the point being is, depending on the nature of the facts of a case, how the law applies to those facts is dependent upon what is found to be the facts by the jury or the judge. So when Mr. Powell says it depends, it does kind of depend more on you can't just say if you're a tutor, what's going to happen. It kind of depends on what the relationship is, what authority the tutor has over the person, where the incident happened, and things like that. So those facts would be somewhat determinative of how the law was applied to those.
And I agree with that. And just as a note, we focused on a case, which is a seminal case from the Florida Supreme Court, which happened to be in the context of a teacher-student relationship, which obviously was kind of the relationship at issue here as well. So that is why most of our discussions were in that context. But I think I agree with Mr. Powell as well as the court that the custodial authority, custody and control could arise in different scenarios depending on the facts. And I think that a tutor very well could, depending on what the relationship between the tutor and the student were.
Yes, ma'am.
I was wondering, the defense is asking for a judgment of acquittal, even though it's not in dispute that Mr. T did have sexual relations with a minor. So I was wondering whether there was some remedy that could be applied that penalizes that conduct, even if it's conceded that there was no custodial authority.
Well, Mr. Teat never acknowledged having any sexual contact, but the jury the jury found him guilty of 1 count out of 7 that he had been charged with. But he never acknowledged, and he gave a statement to the law enforcement. He denied any sexual activity.
And one of the questions we were asking the attorneys is, Mr. Wurtzel is saying, Judge, the case I should have gotten an acquittal, and Mr. T should have gotten an acquittal because, one of the elements that the state had to prove was that Mr. T had custody and control over the 17-year-old at the time. And he's saying under this Florida Supreme Court case, which we are bound by, he says the facts of that case kind of suggest that we should determine that it should be an acquittal as well. We were talking about whether battery charge, that's what's called a lesser included. So in other words, if you're not convicted of the charge, are you guilty of something else? And the only one that was applicable here that was charged by the state in which the jury had the option was a
what's called misdemeanor battery, an unconsented touching. In other words, I come up and I punch you in the mouth. You probably didn't want me to do that. That's an unconsented touching. Where here, the evidence that came out at trial was that it was consensual by the 17-year-old. So she was, it wasn't unconsented by her. And so what Mr. Wurzel's argument is, this should be reversed and an acquittal all across the board and no sanctions, no punishment.
I think from the bigger picture, there can be activity or conduct that individuals consider reprehensible. From the legal perspective, the legislature is the ones that decide what constitutes a crime for which you can be incarcerated. And, there can be conduct that we view, that someone views as reprehensible, which is not made into a criminal offense. So the state, when they charge, they have to charge a particular statute. They say under this statute, this defendant violated the statute, and then they have the burden of proving it. And so, from our perspective, we look at whether they proved a violation of the statute that, that they're proceeding under. And so we have to set aside our views of whether this is bad conduct, good conduct, acceptable, unacceptable. We have to view it as, what did the state prove a violation of a particular statute?
Yes, sir.
She's there.
No.
Let's go. Let's go back here.
This question is directed towards the state. How did you decide prosecution?
Oh, well, actually, I did not. Of course, the criminal appeals unit only handles the appeals. This would have been handled, oh my goodness, in this case, I believe this was Seminole County.
18th circuit.
Yep, 18th Circuit out of Seminole County. So there, each circuit has its own state attorney, of which then there's an umbrella of multiple assistant state attorneys. A lot of them have what we call intake divisions, where they're going to receive criminal complaints, arrest affidavits, or someone coming in and swearing a crime was committed upon. And then there are attorneys specifically there who are supposed to look at these statutes and then state, we think this would be the best way to charge this. If you read through the facts of this case, there was, of course, investigation by law enforcement officers, and then after an arrest, this came to the state attorneys. So the assistant state attorney under the 18th Circuit would have handled this particular process.
He wasn't the prosecutor. He wasn't the one at the trial court level.
And ironically, and I certainly don't mean to pile on the state here, but this was actually the third charging document filed in this case. So a charging document is generally called an information. And in this particular case, there was an information, an amended information, and the case went to trial on the second amended information. So this was actually the third and final time that the state charged the case, which can happen because Mr. Fowler said it may go from an intake attorney to a division attorney, and then as discovery happens, depositions happen, you may say, okay, well, we actually think it should be charged this particular way. So that's kind of a fluid decision based on what the state believes the facts are.
Yes, ma'am.
This question's for the attorneys. What made you decide in terms of whether you wanted to do prosecution or defense for criminal cases?
Where you get offered a job.
Honestly, Judge Cohen has answered for me.
So
Yes.
I don't want to be in charge of calling.
Well, he's had his hand up.
Yeah, I just, so just trying to think of thought process here. I noticed that the two kind of main questions here was authority and custody of the victim. You guys were bringing some hypothetical questions, such as if they were going to a mall or something like that, based on that's the authority. Now, I just, I could completely wrong there, but if the person that alleged crime in this case was a bus driver or something, would that kind of have an effect of, his authority during the transportation, as well as just, that he's not just a teacher that teaches them, from 8 to 5 or something in that sense, that even that transportation is still considered the authority, even though he's not considered the bus driver because he's done it in the past?
Well, one reason we ask hypotheticals or change the facts a little is because, if we write an opinion I mean, it obviously decides this case, but our opinions are controlling throughout our district, and if no other appellate court has addressed it, then it's controlling throughout the state. And so we don't, biggest fear, I think, among appellate judges is the decision that you write causes unintended consequences. So you have to be very careful in your language. So, do we want to write an opinion that's broad enough, or do we want to keep it narrow to these facts, or do we, so how broad an opinion do we write? And, do we include language, for instance, with the mall that says, hey, if a teacher sees a student in the mall, that still fits under the statute or not? So we have to be careful about how broad a language or how narrow we write the opinion. And these hypotheticals can help address that, because we don't want unintended consequences.
Yes, in back. Yes, ma'am.
The student was saying younger, because I, like, when I was after school program, we would have to wait by the line or let the bus move until either the parent picked us up or the bus driver picked us up. Never would a student be allowed to get into a car with a teacher and be driven home, because, as they were saying, they didn't look at parents, whether, in the teacher capacity, when we're at school, once our parents are dropped off, we are in their care. Once we leave, we are no longer in their care. So would it be different if it was a younger student, say, because if they're 16, you can maybe drive their cell phone, they're a little more responsible. But I've never seen those situations where teachers were driving the student home unless it was a familial kind of relationship, because in that capacity, you were putting, the entire life of the child into somebody's hands who may not have a responsibility for the child past the days of school.
Well, familial means family related, like,
Or so even was it the like the consent that we're trying to find for the family or for the
Custodial authority.
yeah,
in that capacity, at what point do we decide that he does not have that role anymore? Because when we're on the school ground, there's been times where, they had to call officers to school to pick up a child because the parent never showed up, but the teacher did not bring that child home. It was not the role of that teacher. If that teacher
We can't answer questions that might impact upon how we're going to decide this case. So what we'd like to do at this point is, thank the lawyers for sticking around a little bit, and now open it up to the students for unrelated to this case, general questions that they might have for the panel, but the lawyers are free to go. Thursday.
okay, yes, ma'am. Well, I mean, that's kind of depends. It depends on our caseload, frankly. We don't. I suspect that we got this case. Once all the briefs are done, then what's called perfected, and it gets assigned to a suite or at one of the judge's offices. And I suspect it's a matter of 60 days before we have the oral argument, and then, depending upon the nature of the case, we usually try to get the opinions out within 30 days of having the oral argument. Sometimes it takes longer. We have kind of a vetting process too, that where we as a panel, if we write an opinion in this case, before it gets released, it gets circulated to the other members of the court so that they can look at it and say, even though they weren't here, they can say, what are you guys doing? Why are you making that decision? This is inconsistent with earlier cases under our court. And so we can then, circle back and talk with the other judges who are on the court who may have a different view or want us to consider something different. So, sometimes it can last, 2, 3, 4 months after we actually have the oral argument before an opinion. Sometimes longer, sometimes fast. It depends on how comfortable we are with where we think the resolution is to be reached.
Nothing, if it's a 3-0 opinion, generally it might go out quicker than a 2-1, because if one judge dissents, then, after that judge writes the dissent, then the other two can look at the dissent, and they may want to change their opinion to respond to something that's in the dissent. And on the dissent, they want to change their proposed dissent to respond to the new version of the majority opinion, so that can affect it.
I mean, we email each other back and forth opinions and stuff. It's not like in the older days where we all sit down and talk, but we'll go and talk after this, but when we actually finalize stuff, or occasionally we'll Zoom again. We do a lot of stuff by Zoom. In fact, I think he was referring one of the earlier cases. Our oral arguments are optional to you. They can appear by Zoom. We have an actual request saying, tell us, do you request to appear in person or by Zoom? In this scenario today, we told them, oh, you're showing up because we wanted to appear in front of you, and they all need to, I think we have one next month. It's in Inverness, and the two attorneys in one of the cases actually are like 2 blocks from our courthouse in Daytona, but they're driving across the state to Citrus, and they're not aware of that yet, but I'm sure they'll be delirious when they see it. But that, it's, we have several law days during the spring that we come out to the communities to appear, so people can actually see, because we actually don't get a big audience when people are in Daytona. Maybe 1 or 2 people there. Yes, ma'am.
Have you ever had a brief or a document that is just, it was not admissible, that you sent it back, and was like, we need to do this? Are you allowed to do that? Does that happen?
Occasionally, a lot of times, the one party will move to strike the brief, saying, you're not complying with certain requirements under brief writing rules, and they want to do that. I mean, occasionally, I think we do it on our own, but it's usually in response to a motion being filed by the other side. But yeah, there's some of the briefs. I mean, a lot of the stuff we have is with pro se litigants. Most of our cases are criminal cases, and a lot of them originate from the people who are in prison who are unhappy years later about, they think their sentence is illegal, or they think that their lawyer was ineffective. And so we do get a lot of paperwork filed by prisoners. So some of them are actually write pretty well, some not as well.
Sometimes the reason for the motion to strike the brief is they refer to things that are not in the record.
And as you saw from the first case, you see how well that goes.
Yeah, I mean, because we're not there, so you can't sit and tell us, well, I know you haven't seen or heard any of this or read any of this, but let me tell you what happened over here, because then the other side will have their view, and we can't discern from, well, what did or didn't happen outside of what's in our record. And it's not fair to the parties for us to do that. And so we don't do that. We're prohibited from doing that. Yes, ma'am.
If a case has an unintended consequence, what's the way to resolve that?
If the case has an unintended consequence, how do you resolve that?
Well, I think what would happen down the road is, if they're in a later case, the attorneys would come back and perhaps try to convince us to, in that later case, to recede from a position that we have taken. So in other words, I know that we had a case from 20 years ago in a civil matter where we set forth a principle of law that just last year, amongst ourselves in a case that had that fact, we said, I don't know if our old court 20 years ago got that right. So we kind of changed the rule of law that applied to the factual setting there. So if we write a broad opinion that people start using down the road, and then we said, well, boy, I'm not sure that was really what we intended to do. That was how it was intended to be interpreted. If we think we need to fix that, for lack of a better legal term, then we would go what's called en banc. The whole court would look at the case and write an opinion that says, okay, what we said before, we're going in a different direction.
Yeah, so 3-judge panel can't say that this other 3-judge panel from our court earlier got it wrong. We would have to, and that, like Judge Lambert just said, we'd have to go to all 11 of us, and then the majority would prevail.
It's called an en banc, the whole court. We would come back and write an opinion saying, okay, we look like we've gone in 2 different directions on two panels. And so we're going to clarify this in some other case. But yeah, we can't just one day, you know, if we rule on this case, this last case you heard, we write an opinion, and then 3 judges down the road have a similar case on our court, says, where did they come up with that? That's not what we're doing. As the 3 don't get to do it. We may collectively say, okay, we've got this new case. Let's think about what you just did in this Teat case today and come up with something depending on what that other case is about. That's how we correct ourselves, if that's the right term to correct unintended consequences or. Yes, sir.
The question I was gonna ask earlier, Your Honor, it seems to me that by the time it comes before your bench, the attorneys have already been through the trial course. They've lived this case many times over.
Well, they're not necessarily the same one who tried the case, if that's what you're asking, but yeah, they're familiar with the case, certainly.
When you get it, you've had the brief, you've read it. So your perspective is going to be you're a fresh audience for those attorneys. Is it that since you look at everything, it's sort of a black and white kind of field, either it complies or don't, so on. Do you find the lens that the court looks through at an individual case creates sometimes a disconnect with the attorneys who have done nothing but live the case?
Well, you know, there's a difference between being a trial advocate and an appellate advocate. So sometimes when you have the trial attorneys who are also appearing on appeal, they're more emotionally involved in the case. And being a good trial advocate is not necessarily being a good appellate advocate. In fact, they tend to be mutually exclusive. I mean, you as a trial advocate, you're trying to convince a jury and there's more emotion involved, where that is really not a good product here. You know, like, in other words, Mr. Palace, he wouldn't come up here and say, come on, judges, you really don't want to let this guy go here. He had sex with a minor. This is terrible. That would not be a good advocacy. I mean, he has to say, okay, here's why we think the law was correctly applied to the facts below and why we think from the state's perspective, you should affirm, but it's not an emotion. So it can't be an emotive kind of thing. But
your focus can be totally different. Like take a personal injury case, a car collision. Okay, at trial, the lawyers are focused on who is at fault and was the plaintiff injured, and if so, what were the nature of the injuries and how serious. And then the jury makes a finding. They say the plaintiff was at fault, 50%, or the defendant was 100% at fault, or whatever. Generally, we're kind of stuck with that. And so when they come upon appeal, the issues we hear is the judge gave a wrong jury instruction, or this piece of evidence came in and shouldn't have come in, or things like that. So then the lawyers need to change their whole focus. Instead of trying to persuade the jury whose fault it was and how much the injuries, now they're focused on, did the judge, give an improper jury instruction? Did the judge make an improper ruling on evidence? So a lot of times what happens at trial, the focus of the lawyers is totally different than their focus in front of us.
And was the error prejudicial? I mean, you may hear that, you have a right to a fair trial, not a perfect trial. I mean, we were all trial judges. I've tried hundreds of cases as a trial judge. I could always go back and look at any case I tried as a judge and say, geez, why did I say that? Or why, it doesn't mean that, well, everybody gets a do-over because the judge might have had a momentary lapse. Is the error so prejudicial that we need to reverse it, or is the application of the law so erroneous that we have to send it back and reverse it for a new trial with direction from us that we tell them, don't do that on the second trial. Yes, sir.
As a general rule, if it's permissible to say, how often are cases affirmed? How often are they reversed or sent back?
I would say well over 90% are affirmed. I mean, there's certain principles apply. What has happened below is presumed to be correct. So the appellant here in cases generally has the burden of showing why that's error. They don't, when you go into trial, there's no presumption one way or another. You as the plaintiff have to prove your case. You as the state have to prove the crime was committed. But once the result happens at the trial court, then what the trial judge has done and what the judgment we get is presumed correct. So you as the appellant starting off with a hard road to hoe because you have to show why there's error and it was so significant that it should be reversed and sent back. So that's why most of the cases are affirmed. Other cases are affirmed for other reasons. One of the principles is you can't make the argument to the appellate court for the first time. You have to give the trial judge a chance for he or she to correct any error. You can't sandbag. Maybe that's an old term for us old guys. You can't sandbag somebody and say, well, you really screwed that up. I just won't say it because the appellate court will fix it. You have to bring it to the trial judge's attention because it's, you bring in jury, you impact the people in the community, you come in, sit on a jury, you spend money on attorney fees and witnesses come in and, you ought to do your best to get it as fair and as right as possible. And if you think an error is being committed by the judge, tell him or her and tell specifically, don't just say, Judge, I object because it ain't right. Well, that's not from Akawaha where I live. It ain't right. But you actually have to have some kind of specific objections, hearsay. It doesn't come with any exception, hearsay rule or something. So the judge can sit and say, okay, I'm going to make my reasoned decision here. And that's what I'm ruling. I understand. And then you make the argument to us saying, we made that argument. The judge ruled this way. We think the judge was wrong. So. Yes, ma'am.
And what percentage of appellate cases do you actually hear oral arguments versus just making a decision based solely on the
2 out of 18, 20%.
I maybe 10 to 20%. 10 to 20% of the cases we might have oral argument. And what happens sometimes too, depending on who's the makeup of your panel, once case gets set for oral argument, if the judges address it fast enough and they may reach a conclusion about the case, even though it's set for oral argument by our clerk's office, we may then dispense with the oral argument saying, we don't need to hear oral argument. We're clear based upon the record and the briefs and the law as to where we're going to go here. So we don't need oral argument. So, but like I said, we get a lot of prisoner appeal. I mean, literally get stuff sent from Liberty Correctional Institution or whoever. And, so we get appeals from them. We don't bring the prisoners in for oral arguments. So.
And that's again, goes back to the importance of the written product. When your case is decided without oral argument, the briefs are going to win or lose the case for you. So it's important that you write well. And one of the answers about how do you write well? Practice. Same way you get to Carnegie Hall, I guess.
Yeah, I mean, when we
write, the better you get.
When we write an opinion, when I write an opinion, I mean, it's not unusual for, my JA type, doing it, saying, we're on draft 22 of the opinion because there's changes, we just keep editing because you try to be precise and you try to have a good flow. I mean, there's an art of writing. There's a flow that this paragraph should follow what I just wrote. So it should be an easy way to read, my wife is not an attorney and I used to, as a trial lawyer, I tried case of trial lawyer. I used to practice closing arguments and opening statements with my young kids at the time, saying, I want to be able to talk to you till you understand. So when I write, I want to be able to be understood, not that you have to get out a legal dictionary to write understand anything I write. Probably can't understand what I write anyways, but I can't.
And legal writing is much different than writing a novel. I mean, we're looking for precision, getting to the point, a whole lot less adjectives usually in a legal writing than in a novel.
In the old days, there used to be like a 50-page limit on the brief. Now we go by word and font for some reason. You need to ask Tallahassee about that. But so there's kind of an old metaphor. Just because you can use 50 pages doesn't mean you have to, because we have to read a lot. And, when we get our memos from our staff attorneys and we open it up and it's like the memo is 143 pages and you're going, really? You find out a lot of it's got attachments, so it's just exhibits. So, but I mean, it's still a visceral thing on why you need to have 112 pages to explain this case to me, really? Yeah. Any other? Yes, ma'am.
You made the attorney before you left made a comment about being a law clerk. What qualifications do you need to be a law clerk? Is that something that you would need your bachelor's and then apply? And then where would you, like, how would you, is there like a website?
You got to be a lawyer. So, and you apply.
We get your transcripts, we get writing samples that you have prepared in law school. You know, we probably have 30 or so lawyers that work for us at the court. Well, not actually at the courthouse, but they work for us. We do have an internship program where, like, you know, first or second year law students apply for summer internship, and I think I'm sure it's an unpaid internship, but I mean, you learn and you work with our staff attorneys, and if, you know, you're interested in doing that kind of work. I mean, there's applications to apply for the internships that we have. So, and I don't think we have a specific set amount. I think it depends upon the judges, whether they want to have an intern. I mean, I've occasionally had interns, some summers not, some do. It depends on, you know, depends on the judge's case, how well the intern strikes you as going to be a good person to work with. And
in terms of law clerks, you know, I don't interview anybody that probably isn't in the top 5% of their class and doesn't have either law review or moot court background, because being a law clerk is a very difficult job, because you've got complicated issues that you need to address. And as you could see, one of the great parts of this job is look at the variety that we handled just today. You had, you know, a contracts case, you know, you had, you know, a criminal case, you have an attorney's fees case. Well, the law clerks have got to see cases from almost every end of the spectrum except for death penalty cases. And it's a very difficult job. And so I look for people that have had great success during their law school careers.
They really need to have excellent legal research skills, excellent ability to analyze legal issues, and excellent writing skills. So,
and just as an aside, we don't avoid death penalty cases just because we don't like them. They actually are required to go to they skip from the trial court to the Supreme Court when the death penalty is imposed. I actually tried death penalty cases when I was a trial judge. So did Judge Cohen, so we all tried death penalty cases. But if death is imposed, then it on appeal it goes up to the Supremes. So it's not like we don't like it and say, well, we don't do that. So we're not permitted to do it.
Although we're okay with that.
Yeah, we're not sad about that. Death penalty cases, when you try them, they're extremely lengthy. They can be very lengthy and time consuming, and the records are enormous and the issues are enormous because you know, obviously you're dealing with the most final of penalties. So they're time consuming and they go right up to the Supremes. We thank them for that. Anything? Last question.
So how is the three-judge panel determined? Like, is it random from the, there's what, 11?
Yeah, it's randomly assigned.
Something like that.
Yeah, we don't get pick and choose at each other. It's randomly assigned. So when the briefs are all done, if the case is ready to be assigned, then we just get it, the clerk sends it to us. I mean, we know our calendar is set. So, I mean, I know my oral argument schedule for the rest of the year, who's on my panels in October or November or what have you. But the cases are not assigned yet. So we don't know any of that.
And the panels are done are randomly in the sense that they're set up so that we sit with every member of the court a relatively equal number of times. It's hard to get that exact, but we rotate so that we're sitting with different people on the court so that you're not, you know, that's fair for the litigants and fair for resolution, for development of the law, so that you're not sitting with the same people all the time. You're going to sit with everybody on the court, and it's all mixed.
And just as a matter of randomness, you got about the oldest panel our court could produce today.
What do you call it? You have the most,
3 of the 4 oldest are here.
you have the ones with the longest judicial experience combined, actually, the 3 of us. I've been a judge for just over 22 years. Judge Evander's been a judge for a little over 33 years. Judge Cohen became a judge in 1899. So.
I know,
Oh,
that's what I.
so, but he's been a judge for 32
Yeah, they're-
32 years. So I think we have one other judge who's older than me, but he was a trial attorney. He was an appellate. He's been an appellate judge for 7 years, but he wasn't a trial judge before. So actual sitting with robes, being in courtrooms, we have the most experienced judges on our court sitting with you. And it was just random. We didn't all say, let's all show up and put on a show for you. It was just random, but that just happened to be how the luck of the draw is.
Which could be good or it could be bad. I don't know.
And then, judges have different philosophies. I mean, you hear a lot of the issues now coming in, obviously, they're having a Supreme Court. They're having a hearing about the one justice that's to be appointed. And there's a lot of philosophical, political discussions that go on, and you have different philosophies of judges as you go through the years. And certainly, we have that in Florida as well.
And one shift in time when I think that probably the 3 of us became judges, typically you had to be around for a while and have a few gray hairs before you got put on the appellate court. But that's no longer the case. Now you're getting people that are in their 30s appointed to the appellate courts, and that's there are reasons for that that are political, that are above my pay grade. But that's just a difference in how things have developed over the course of my legal career. Thank you.
Yeah. Okay. Well, we thank you all. We are going to have, I'm not sure how the lunches are. We're all going to have lunch with everybody or what? Okay. We certainly enjoyed our time with you. Yeah, we don't have that much money to spend. We can't afford it, y'all. We certainly enjoyed our time with you. I hope you enjoyed being with us, and we look forward to coming back next year. Thank you. Except Judge Cohen will be in Lakeland.